Yes, Mr.
Hello, with a lot of indulgence. I'd like to mention item 6. Can it be taken at 2 p.m.?
6.
6.
Okay.
Obliged.
For withdrawal, item 1.
You have to withdraw.
It is compromised between the parties. That is why I want to.
Mr. S.K. Ghosh, the Learned Counsel submits that the matter has been settled out of court, and as such, the appellant would not like to press the instant appeal. Accordingly, the instant appeal stands closed on withdrawal. Interim orders so passed. In MC 415/2010 that stands vacated.
LCR.
Hmm?
LCR.
The LCR be returned by the registry forthwith to the Learned Courts below.
For motion, item 2.
Can be taken up after some time. Madam, senior is on election court number 10, madam. Sorry, court 8, madam. Sorry, madam, I am for item number 3, madam.
Please, your lordship. Lordship, my senior is election honorable lordship, kindly pass it my
Who is the senior?
Mr. T. Mohanto. He's coming, lordship.
Hello.
Deeply obliged.
I can't dismiss in your hands. I'll dismiss it when your senior comes.
But for item number 3, I have a similar prayer, my lord. Let it be taken up after some time, my lord. Item
Huh?
number 3, my lord. But my senior is on election court number 8, my lord.
Item 3.
What are you challenging?
We are challenging the order passed by the additional district judge Johar, my lord, passed in Miss Appeal. Miss Appeal number 18 of 24, my lord. Whereby the injunction order passed by the Learned Trial Court was satisfied,
Injunction order.
my lord.
Injunction.
Injunction order.
Appeal dismissed.
My lord, appeal was preferred by the defendants, my lord. Miss Appeal was preferred
Huh?
by, my lord, we filed title suit, my lord. And we were given an interim protection, my lord, by the Civil Judge Senior Division Johar. Challenging that, my lord, the defendant filed Miss Appeal
So you want to your senior?
my lord.
Sure. 8282, last item of the day.
Obliged, my lord.
Item 4.
Legal lordship. Lordship, my lord, this petition has been filed challenging the judgment and order dated 26/9/2023 passed by the Learned Additional District Judge, my lord. In Miss Appeal number 76 of the 2021, whereby the appellate court was pleased to set aside the eviction order of the estate officer under Public Premises Act 1971, my lord.
What is the ground?
My lord, Lordship may kindly come to the order, my lord. Page 53, my lord. It starts from page 42, the relevant part, my lord, I am reading it out. May I read it out, my lord? Page 53, first paragraph 12. From the above, it is apparently clear that there is no judgment passed by there is a judgment passed by the additional district judge, FTC number 4, in Miss Appeal number 28, public 2015, and thereby set aside the eviction order passed by estate officer in respect of the same plot of land, and the same judgment was not challenged before the competent court of law. Hence, the same judgment is in force.
No. First and foremost, after the judgment passed in Miss Appeal
My lord.
by the additional district judge, when did he pass?
My lord, initially, my lord, in 2015, 5/6/2018, my lord. And the second one, my lord, Miss Appeal number 76/2021, it was disposed on 26/9/2023, my lord. Now, my lord,
Show me the earlier judgment.
judgment, my lord, Lordship may kindly come to page 24, my lord. These are the observations made while passing the setting aside the order, my lord. Page 24. my
No,
lord.
not this one. The earlier judgment on
Then I
the
have-
basis of which he held that it to be finality.
My lord, that order I have not annexed, my lord.
Mr. Counsel, what is wrong with you? Earlier you had another counsel now, Mr. K. Gogoi.
My lord, yes, my lord. Same case, my lord.
And
three
the
cases,
best part about him is he brought that judgment
my
and
lord.
it is the same set of case, I
My lord,
suppose.
here I have the orders, my lord.
Yes, then you have that order, but the main thing is I think most probably in the earlier thing, it was held that the notice was not properly served.
My lord,
And as such, it was held that this could not have been done.
my lord,
And then I passed on the date of the motion itself that order.
my lord,
But here I can't help you with anything because the other side is not there.
my lord.
You know?
Let,
So what do I do? Tell me.
let notice go, my lord.
Huh?
Notice.
You are not in urgency.
Oh, my lord, because all these land are under the same dock, my lord, including those three, my lord. My lord, lordship can dispose of also, my lord.
Huh?
Lordship can dispose of also, my lord, on the basis of.
I can't dispose it off because of the fact the other side is not there.
My lord,
In those cases, the other side was there.
there, my lord.
He was on
Without
KVR.
issuing notice, my lord.
And this time they have become clever not to be on KVR.
My lord.
Okay, issue notice. Where are these people? It's here, na? Can you serve it by Dusty?
My lord,
Hello, issue notice. We finish it before vacation.
my lord.
Issue notice making it returnable on 25th of June 2025. Steps be taken upon the respondent by way of registered as well as usual during the course of the day. Further to that, the petitioner is directed to take steps upon the respondent by way of Dusty routed through the registry of this court and file an affidavit of service on or before the next date. The learned counsel appearing on behalf of the petitioner has submitted and has drawn the attention of this court that the learned court of the additional district judge number 1 Kamrup Metro at Guwahati failed to take into consideration that the earlier judgment on the basis of which earlier judgment passed in Miss Appeal number 28/2015 was only in respect to passed in Miss Appeal number 28/2015 had set aside the eviction proceedings on the ground of failure to observe the principles of natural justice. He therefore submitted that under such circumstances, the fresh steps were taken and fresh eviction proceedings were initiated. He therefore submitted that the learned Court of the Additional District Judge number 1, Kamrup Metro at Guwahati, failed to take into consideration the same. And it is under such circumstances the present proceedings have been filed. Pusto. Taking into account the above, this court shall pass appropriate orders upon appearance of the respondents. You bring on record, was a liberty given to the petitioner to bring on record by way of an additional affidavit the judgment passed on the basis of which the impugned judgment and order has been passed.
My bad. Duplicate, my bad.
5,
Miss appeal to agote কৈছো না miss appeal number, passed in miss appeal number suits. Yes, what is this?
My lord, I am here against the injunction petition, my lord. Initially, the injunction petition was rejected and subsequently I have approached before this honorable court by filing FAO that was due to pecuniary reason that was remanded back to the additional district judge Kamrup Metro. And that was renumbered as miss appeal. Miss appeal was rejected. And I am here against that order, my lord, as because, my lord, petitioner is so old lady and the title suit is pending, my lord, before the trial court, my lord. So till that disposal, my lord, title suit, my humble submission before this honorable court is stated up to my lord as the petitioner running a tea stall in the government land, my lord, DTO in the premises of DTO office Uluvari since 1987, my lord. And till now, she is continuing and till date, continuously she paying rent
Two?
to the government.
How?
My lord, that is, my lord,
No, you don't have a license. The license has expired long time back.
expired, my lord, in 16,
Then-
my lord.
What is your basis to remain?
And that is, it is pro court, my lord, rent is
Who?
pro court, my lord.
How?
It is, my lord, one case is there. On the basis of that case, the petitioner depositing the monthly rent.
Are you a tenant
Yes, my lord,
of?
of government, PWD, my lord, IWT, Inland Water Department, my lord.
You're a tenant.
My lord.
Show me your landlord-tenant
That,
relationship.
That tenancy agreement is expired, my lord, in 2016.
Let us see the tenancy agreement.
My lord, it is, my lord, page 29, my lord.
Hmm.
In 1992, subsequently it is time to time extended.
This is a license, not a tenancy agreement. It is written in bold letters, deed of license.
My lord, to my lord. Deed of license, my lord, page 33, my lord.
29,
33, my lord.
29.
My lord, deed of license. That was also extended subsequently.
License, hence, you
And
should have vacated.
that was also
Hmm.
extended another by 27/12/2023.
Okay.
And
You are asked to run a canteen.
Well.
My goodness, this can't happen. Too much. This is only for a period where it is categorically mentioned. The licensee shall have no right to make any addition area license and maintain area deducted from area from adjustment of so and so may be renewed after the expiry of the period of the lease by enhancing, increasing the monthly area. Was it renewed? No.
no, my lord.
Then-
And
And
after
the period
expiry,
ended when?
my lord,
Period ended when?
It is, my lord,
And what are you challenging? Why? Why did you file the suit? With reference, you are hereby informed that the canteen lease cannot be renewed at requested as the space occupied by your canteen at Olive in the so and so is required for other purpose. Therefore, the earlier order of allotment of the canteen of your is hereby cancelled in the interest of Iman. You are asked to vacate the premises occupied by your area within 1 month. This was given in 2017. And then also you have been continuing.
my lord,
Which one do you want? Dismiss with cost? And why you are not taking action under the Public Premises Act? You can't throw somebody out. No, forget about the suit, but then also whatever maybe it's a due process. Maybe they initiated action under the Public Premises Act because the ASTC comes under the Public Premises. Now there is no interim order. And then he's going to, I'm dismissing it right away with cost. 10,000?
my lord, I am withdrawing, my lord.
Huh?
I am withdrawing, my lord.
Withdraw, better withdraw. These type of cases. Heard Mr. K.U. Ahmed, the learned counsel appearing on behalf of the appellant. Petitioner, Mr. G.N. Sahiwala, assisted by Ms. Estudi. Huh? So and so, who appears on behalf of the respond ASTC. The learned counsel appearing on behalf of the appellant, petitioner submits that the petitioner would be well advised not to further press the instant proceedings. Who's taking into account the above, the instant proceeding stands closed on withdrawal. This court, however, finds that if the respondent ASTC takes steps for eviction of the petitioner, the same should be taken by the resort to the relevant provisions.
Item 7,
May please your lordship. My lord, in this case, I prayed to allow the written statement, but learned.
Huh?
I prayed to allow file written statement after the limitation period 45 days. My lord. The learned tribunal refused to accept my petition and not allow. So, informed order is 64 page number, my lord. Denial of opportunity of finding WS retention is a banking register. I want to contest, my lord, in this case. So, ex parte case proceed. So, prayed for vacating ex parte order, given opportunity of filing, contesting the case, my lord, at least. Filing affidavit evidence or contest the case, filing WS. Principal money already paid, my lord. Only loan money in principal loan already paid. Opportunity is taking, my lord, to contest the case, filing affidavit. Others, I am ready to pay the entire loan money, my lord.
What is the next date?
Next date, my lord, I was sorry, forget, but within 1 month. It is pending within one month, my lord.
Okay, we'll issue notice only, no stay.
My lord.
Keeping the question of limitation open,
Well-
maintainability open.
My lord.
Issue notice making it returnable. Who is the bank? We only won one. Who has
Only-
filed that proceedings?
Yes, my lord. I'm a defendant number 1, my lord. I am the main defendant number 1. I
So who has filed the proceedings before the DRT?
bank opposite party.
Respondent
Respondent
number one.
Respondent number 1.
So we don't need 2 and 3.
my lord.
Why do you need 2 and 3? You want to delay the proceedings? 2 and 3 not required.
My lord, I am saying always give an opportunity to contest the case by filing.
Understood. So we only have 1. Why 2 and 3? 2 and 3 is your co-defendants.
Yes, my sir. Not
So why is
necessary.
it required? So
Not
we have only 1.
Yes, I will strike out the other.
No, not necessary. Issue notice, notice upon respondent number 1, making it returnable on 25th of June 2025. Full stop. The petitioner is directed to effect steps by way of registered as well as usual during the course of the day. Full stop. The petitioner further is given the liberty to effect service upon the respondent number 1 by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. Full stop. The petitioner herein have assailed the order dated 7/3/2025 by which the Learned Debt Recovery Tribunal Guwahati had rejected the application for accepting the written statement. Full stop. Taking into account the above, this court is of the opinion that without hearing the respondent number 1, it would not be in the interest of justice to pass any order. Full stop. Any appropriate order, if so necessary, would be passed only on the next date. The maintainability of the instant petition is kept open.
Supplementary item 47.
If it pleases you,
Hmm.
Lordship. Here, your Lordship, application has been filed, your Lordship, for transfer of TSM number 83/2024, which is pending before the Learned Additional District Judge at Jorhat to the Learned District Judge Tezpur. Because, your Lordship, there is a coverage of 164 kilometer, your Lordship, and the petitioner is solely dependent on their parents, your Lordship. She does not bear and cannot bear any expenses right now, and she is financially broke down. And her mentally condition is also not well, your Lordship. She has been taken counseling for to refrain her mental ability, which I already stated in paragraph 4, that is of page 4. That it is, I would like to read it, your Lordship, that it is humbly stated that the petitioner wanted nothing but respect and love from the wedlock with the respondent, but unfortunately the outcome result is very unfortunate, and it the result of outbreak of the petitioner mental health as well as physical health. The petitioner has taken counseling to refrain her mental ability. And
Madam,
lost-
everything and I understood. What is the stage of the proceeding?
Your Lordship, I have annexed it, annexure 24.
There is no annexure 24, page
Pa-
20.
I'm
Yes.
sorry, your Lordship. Annexure 4, page 24.
Understood. What
Here,
is the
your Lordship,
stage?
now,
First
your
of all,
Lordship,
you did not file your written statement.
yes, your Lordship,
Matter has proceeded for cross-examination of
cross-examination. Yes, your Lordship.
So that
That
is
is
it.
admitted position, your
So what
Lordship.
is there?
So, your
Why do you
Lordship,
need a transfer now?
your Lordship, since your Lordship, she cannot bear the travel expenses and her mental ability is also not well, your Lordship. And traveling from
What is
that
wrong with her?
distance, your
She's
Lordship,
30 years old.
Your Lordship, still her mental ability is not well, your Lordship,
Where
because
is the
she's
certificate?
taking, she's,
Where is the medical certificate for that?
your Lordship, she's taken meditation, your Lordship, by form of yoga, and your Lordship, doing all the practices, your Lordship. So, your Lordship, kindly, I pray for your Lordship.
He has the
at
money
this-
to go and have the yoga.
Your Lordship, it was,
Join a
it
yoga
was-
session.
it was giving free, your Lordship, counseling. That counseling is given free, your Lordship. So,
Well, what is
we
the
need to
proceeding
that,
for?
Your Lordship,
It's
I'm
all the
just-
marriage.
your Lordship,
You want to protect the marriage.
your Lordship,
You don't want to give divorce.
Lordship, that I cannot state it, your Lordship, because
No, you are the legal aid counsel, and therefore you tell me, why should this court interfere at a stage when the suit is proceeding ex parte?
ex parte, your Lordship, she cannot bear the expenses, your Lordship, for proceedings, your Lordship.
So unless you set aside that order, unless you challenge that order by which it has been proceeding ex parte against you, before that court or under 227, were you asking filing a transfer?
Your Lordship, she is praying for your Lordship your Lordship, if that petition is transferred to
Legal aid,
That's
no,
for
you
your
should have
lordship.
given a better advice. You should have challenged that order before this court, that an opportunity may be given for her to file her written statement. And then ask for transfer. But what you are asking is the proceeding is going ex parte and it is at the stage of cross-examination of PWs. You have come before this court and now if I transfer it, what does it make? That you are going to cross-examine here?
She can take your lordship, their legal aid service, your lordship,
Where?
Tejpur.
The Tejpur she will get. She's not getting it in
Your
Jorhat.
lordship, there, your lordship, she has to travel all way, your lordship, distancing 164 kilometers.
So she doesn't have to go every day to
Your
the
lordship,
district judge court.
date has given your
Who
lordship.
is going to cross-examine in a district judge court? Is she going to do or a lawyer will do? Tell me. You see what, does she actually want to cross-examine or not? Madam, give me a good idea. The legal aid cell out here have not given proper advice.
She has been constantly, your lordship, pressing your lordship for transfer, your lordship,
Where
to,
she has filed
Which
it now at the stage of PW cross.
at your lordship.
And after that, she
hometown.
can't give the evidence. So only one date is left. Then the matter will be coming for arguments. Because you can't lead evidence as you don't have your anything, you don't have a defense, so you can't lead evidence. So only one date is there, that is cross-examination. That's all. How does it make any sense for this court to transfer now?
At this stage, your lordship, notice may go, your lordship.
Why should I issue notice? I can do one thing good for you is this.
That order, your lordship, which has passed your lordship on dated 8/1/2025, that may your lordship allowed your lordship, one date may be given to her, your lordship, to already order has been passed ex parte, your lordship.
What should I give you?
Your lordship, some relief has been given, one date may be given, your lordship, to produce. And then thereafter, if she approach transfer petition, that may, we can file it, your lordship. But
You,
here
did
already.
you
ex
appear,
parte-
have you appeared before that court ever?
Only, your lordship, dated 6/5/2025, that is annexed as annexure 4, page 25. There, your lordship, it is clearly shown that both parties are represented. Peru's petition filed by the LAC, Bijuli Lata Das, for the respondent with a prayer for adjournment showing cause.
Legal
Peru's-
Aid Council. Vizulota Das for the respondent with a prayer for adjournment showing for third, so and so cross-examination. That is
There,
it.
your lordship, can visibly seen, your lordship, that she, there also, your lordship.
So you have got a legal aid counsel there.
There, your lordship, legal aid counsel, some other person is there, your lordship, representing her, your lordship. But there in 6/5/2025 order, your lordship, it's shown that both parties has represented
So you have appeared through a legal aid
legal aid
counsel.
counsel.
So what order should I pass?
Since your lordship already, your lordship, 90 days has been lapsed, your lordship, reflecting in order, your lordship, 8/1/2025, page 23. Your lordship, kindly one date may be given, your lordship,
For
since already
what?
cross-examination, here, your lordship, it's shown that it was written statement is rejected, your lordship. Her written statement is rejected.
Not rejected. Where she didn't file it. Where is the question of rejection? Has it been rejected? No, it has, she has not filed it.
Yes, your lordship, she is not filed it, your lordship. She is
Considering the
not
above,
aware of the
peruse the
facts, your
tracker, it
lordship, and the
reveals that so and so
circumstances.
thus it appears that time even today, no written statement he has filed. He's absent, see, OP is absent.
Yes, your
So
lordship.
the written statement was there
She
on
is not
7th.
aware the circumstances also, your lordship. She is not aware the
do you do?
circumstances also, your lordship.
What do you do?
One date may be given, your lordship.
Madam, what do you do?
She is doing nothing, your lordship. She is earlier jointly, both husband and petitioner, your lordship, they engaged doing one business. And now she is wholly dependent upon her parents. Your lordship, she is doing nothing right now.
Hmm?
She is doing nothing, your lordship.
How do you know?
She's wholly, she stated it, your lordship. She wholly is dependent, solely dependent on her parents. And respondent is a well-settled businessman, your lordship.
Have you filed any case here in Tezpur? Madam, you should be giving proper
Your
advice.
lordship, I already asked her, your lordship, but she is not able to state any case date, your lordship, any mentioned case number, your lordship.
Has
Because,
she filed any case in Tezpur?
your lordship, that
Why she is not asking for money?
pertaining, she did not claim for maintenance also, alimony, anything, your lordship.
Alimony, she will do it there in the
Your lordship,
divorce, but I'm
yeah,
asking you.
Claim of maintenance, I asked her clearly, but she is not in state of stating anything clearly. Only just handling this, that too, we have to ask her. She is not aware of anything, any circumstances.
So
So,
whatever has been stated is what you have stated.
no, your lordship. No, your lordship.
she is
No,
not in
your
a
lordship.
position to say anything to
Like
you.
claiming, your lordship, she is not able to give her any earlier cases number, your lordship. I asked her repeatedly in the legal aid council itself, your lordship, but she is not able to. She told that the earlier engaged advocate, your lordship, she is not picking up her calls. So, your lordship, she is not aware of any case number and not giving her in hands any number also.
But how
Case
do I
number.
help you? If this is the state of affairs, actually she doesn't want a transfer.
She wants to transfer it.
How, why?
Because the travel expenses, she cannot bear it. And here, your lordship, there is a distance of 164 kilometer. And that travel expense,
But has she told you about that?
yes, your lordship, that she is straight, your lordship, that she praised me, your lordship, that since I am wholly, solely dependent on my parents and no
And what
maintenance,
does the parents do?
your lordship,
See? I'll help you anyway. Give me something to pass an order in your favor. You're not helping this cause. Chalo, lekho. Issue notice making it returnable on. Can you effect her service upon the respondent? Draw this order.
your lordship, I will take steps, your lordship.
Issue notice making it returnable on.
Your lordship, I want to, your lordship, raise one thing, your lordship, that on dated 6/5/2025, next date is 6/6/25. That is very upcoming Friday, your lordship. That thing, your lordship, should be stay, your lordship.
25th of June, 2025. At the outset, it is relevant to take note of that the instant proceedings is being moved through the Legal Aid Council, taking into account that the petitioner herein does not have any source of income. Considering the above, this court therefore directs the registry of this court to take appropriate steps upon the respondent by issuance of notice and also effect service by way of effect service through the court of the additional district judge, Jorhat. And submit a report on the next date. This is an application filed under section 24 of the Code of Civil Procedure for transfer of PSM 83/2024 pending before the Court of the Learned Additional District Judge at Jorhat, which is proceeding ex parte against the petitioner on the ground that the petitioner had not appeared and had also not filed a written statement. It is seen that by an order dated 6/5/2025, the next date is fixed on 6/6/2025 for cross-examination of the plaintiff witness. This court have also taken note of that on 6/5/2025, the petitioner herein was represented by the Legal Aid Council. And the next date has been fixed on 6/6/2025. This court had also inquired with Ms. P. Dasna,
Yes, Your Lordship.
appearing on behalf of who is also a legal aid counsel, as to whether any application has been filed for the purpose of filing the written statement. To this, the the counsel submits that no such steps have been provided, taking into account that the petitioner herein is unaware about the legal complexities of the proceedings. Taking into account the overall facts of the case, and as this court also exercises the supervisory jurisdiction under Article 2 to 7 of the Constitution, this court directs the learned court of the additional district judge at Jorhat to adjourn the proceedings being titled suit M 83/2025 till the next date. In the meantime, this court grants the liberty to the petitioner through the Legal Aid Council to file an application seeking providing reasons as to why she should be permitted to file her written statement. List according.
I'm deeply obliged.
You file that, asks whoever it is to file that application.
Yes, sir.
File an application under Order 9, Rule 7, and say that this is the reason you could not. Then once you file that, we'll take it up and do it.
Yes, sir.
Transfer it. But
I'm
without
deeply
that, you
obliged.
can't do.
I'm deeply obliged.
48,
Sir, my senior is on legs in court number 5, my lord. I will pass
Okay.
over the matter.
To be taken up as the last item of the day.
For admission, item 8.
Tell me,
Okay, so this is an applications challenging the rejection order of substitutions and abetting the
have you taken by way of dusty service?
already taken and this honorable
Service done affected?
affected. This
Okay, now
honorable
what are you challenging here?
this
27/5/2015.
yes, Lordships.
What is that order for?
This is an application has been filed by the the petitioner.
So your application under order 22 rule 4 has been dismissed on the ground that you have not filed an application under for condonation of delay. That's the reason?
That's the reason. That's the reason. But within a period of limitation, I have filed for the substitution application as directed by the learned trial court below. On 11/6/2024, an application has been moved by the respondent with a death certificate stating that the respondent the respondent number 1 has been expired. The moment I have getting the 11/4/2020
11/6 or 11/4?
11 11/6.
Then
That the
2004 or 14.
14.
So he informs under order 22 rule 10A.
No,
They-
he has
yeah.
never filed any application under Rule 10A. But he informally filed an application along with a list of legal heirs, the names of the legal heirs before the learned trial court below. And on 11/6/2014, the learned trial court below has allowed me to file and substitute.
When did the person die?
The person died in 2013. 26/9/2013.
Huh?
26/9/2013.
26/9/2013.
And on the date on 11/6/2020 2014,
Then when did you file that petition?
that application has been filed on 12/6/2000 sorry 11/7/2014.
11/7/2014. How, where do I get it?
In my petition, Your Lordships,
Your petition, forget about your petition. Where is it?
is page 46, Your Honor.
Huh?
Is page 46, Annexure D, page
40.
I've stated that the respondent number 1 on today on 11/6/2014, I
What is
filed
the date of filing this petition? At page 40.
page 46. I have mentioned that that I have filed a petition on 11/7/2014. May I read the paragraph, Your Honor?
Don't read it
Lordships.
because there is no date mentioned here. Then what happened?
That the substitution application subsequently by the impugnator has been rejected and abating the appellant number 1 from the appeal, title appeal, which is pending before the learned court below.
And therefore you have moved here
Since the
and got a stay.
Lordship, but since the application for filing substitution is itself is a application for abatement, so in purview of the date that this honorable appellate court judgment, Your Lordships, the
Which one?
and in 2000
Name?
name, Your Lordships, Gangadhar versus Rajkumar, and recently on 11/2/2025, the honorable appellate court has clarified everything. The moment you have known about the fact that the person has been expired, when an application has been filed in view of the Bhagwan Das case, Your
What is
Lordship,
that judgment?
may I read the relevant paragraph?
No, the early next one.
That
Om Prakash,
the
Om Prakash Gupta.
Lordship.
Om Prakash Gupta.
But the thing is, on
Om Prakash Gupta, yes.
Give it to me.
Lordships. Already on record, Your Lordship.
I don't require so many judgments, only one.
This one.
Arguments finished. What do you have to say? First of all, the counsel who represented before that court on behalf of the appellant number one. Appellant number one.
Yes, yes, yes. Appellant number one. Thekara Bori, Your Lordship. Oh, sorry, defendant number one. Sorry. Sorry.
The respondent number
Respondent
one.
Respondent number one. Sorry.
The respondent number one, whoever had appeared out there, wasn't it his duty under Order 22 Rule 10A to inform immediately? No, you have duly informed. Only on 11/6, then he filed it on 11/7.
Not bad, not bad.
But what is your duty? Did you perform your duty as a lawyer? No, forget about him. Did you inform as a lawyer? Wasn't it your duty? Was it in an appeal?
Yes, appeal.
Where is the appeal? Memo, appeal.
Uh,
Who died? Defendant number one.
Lordships, I have page 41, Annexure C.
But they were already there. Then why should it abate? So obviously it is not a question of debating. Why the court dismissed it? Huh? 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 What is wrong with this court? Where is the page 40? Where is the petition?
Application is page 41, Annexure C, title appeal, Your Honor.
Page 40.
One and
Page 40, yes.
41.
Okay. This is Thekara Boro leaving behind so many. And legal representative. Sons, all other sons were not parties.
No, not party, but
Ah. No, that I'm not going to look. Yeah, who are those people?
they
So
have
now he wants to bring these people.
they are furnishing list of with legal hires. Before the landed trial court, they have furnished the list. This is the persons along with the death certificate.
Chalo. Mr. Paul, nowadays I only on affidavit I make it. Forget about all these things. I don't require all this. Heard, Mr.
H. Bora.
So and so appears on behalf of the petitioner, Mr. R.C. Paul, who appears on behalf of the 1, 2, 3. Who are the plaintiffs? You are the defendant. Full stop. None, the other defendants are, however, not represented. Full stop. The present proceedings under Article 2 to 7 of the Constitution is filed assailing the order dated 27/5/2015, whereby the learned court of the civil judge K. Where is K?
Kamrup.
Kamrup, civil judge Kamrup at Amingaon had dismissed the application filed under, rejected the application filed under Order 22, Rule 4, read with Section 151 for substitution of the legal representatives of the appellant number one, respondent number one. And further held that the appeal abates it. Have been rejected, have rejected the application filed under Order 22, Rule 4, read with Section 151 on the ground that along with the said application, there was no application filed for condonation of delay. First, this court duly takes note of that the appellant number one expired on 26/9/2013. No, respondent number one
Respondent.
expired on 26/9/2013. Pusto. The respondent number one was duly represented by a counsel in the said appeal proceedings, being titled Appeal Number 42/2014. However, it was only on 11/6/2014 it was intimated to the learned First Appellate Court that the appellant number one expired, leaving behind the leaving behind
Ten numbers of
10 legal representatives. It is very pertinent to take note of that the respondent number 2, 3, and 4 were also the sons of the respondent number one. And as such, they were also legal representatives within the meaning of Section 211 of the Code of Civil Procedure 1908. Therefore, the interest of the respondent number one, therefore, the estate of the respondent number one was duly represented substantially. First, under such circumstances, the said application so filed under Order 22, Rule 4 was, in a sense, an application filed under Order 1, Rule 10, 2 of the Code for bringing on record the other legal representatives of the respondent number one, taking into account that there is no period of limitation prescribed for filing such an application, and accept its application under Article 137 of the Schedule to the Limitation Act 1963. The application so filed under Order 22, Rule 4, the application so filed by the appellants could not have been dismissed by the learned trial court, but learned First Appellate Court. Considering the above, this court, therefore, allows the said application, which was registered and numbered as
registered number 544/2020 14.
544/2014. 2014 and impledes.
Sorry, extremely sorry, Your Honor. 445/14.
What is wrong with your dates?
Also, I think-
Huh?
Sorry.
Are you sure?
Yes, I have the order.
445/2014. And impledes. Who are the people?
Uh, uh, Page 46 of my application, I mentioned the names. Paragraph number
Page?
5,
Page
46, paragraph number 5
46 of what?
of my application before the landed trial court. And
Mr. Counsel, what is wrong with you? This is your application.
the names you have already been mentioned in the order itself also.
Where? Your application, all these Binita Boro, Lakshmi Boro,
Lordship.
how are they connected? Why are you making these people party?
Because they are sons and daughters of the respondent number 1, Your Honor.
How do you say so?
Because they have furnished the list.
Where is that list? Where is that petition?
But I have the order of the landed trial court below, Your Lordship.
You have filed, Mr. Counsel, you are not helping the cause of this court. You don't know, you take your seat. You are not helping it. Mr. Paul, who are the legal, because I see something else in your affidavit, written objection. Kindly come to page 45. In reply to the statements made in the appellant at 5, as regards the name of the legal levels also, and so submits that the petitioner have wrongly given the names of Binita Boro, Lakshmi Boro, Potima Boro, so and so and so and so and so and so, as they are the daughter-in-laws and grandsons of Thekera Boro. The Binita Boro is the wife of Bhuvaneshwar Boro. Lakshmi Boro is the wife of Ratneshwar Boro. Pratima Boro is the wife of so and so, while Brizu Boro is so and so. Now, who should be there?
But the
Don't take your seat.
Lordship.
Who should be? You have filed a petition. You have filed an affidavit also, I could see. Where? With an objection. Where is your petition? Page? No, that I have seen it. No, who are the legal representatives of Thekera Boro? Thekera Boro was here. Huh? Where is your application file? Because unnecessarily you don't need to make those people party, na? Now you have given a petition. You have a copy of it. If you can't say that, then it is not necessary to implead these people. Lakshmi Boro. Huh? Stands, this code therefore, কি লিখলে? Last thought. 445 of 2014 and thereby directs the learned First Appellate Court to implead the other legal representatives of the respondent number 1 in terms with the application, in terms with the petition filed by the respondents, providing the names of the legal representatives of the respondent number 1 dated 11/6/2014. Taking into account the above, it is further seen that in view of the present proceeding, the further proceedings of title appeal number so and so, title appeal number 42/14 have been stayed by an order dated 24/8/2015. The said proceeding stands, the stay order stands vacated, and the parties are directed to appear before the learned First Appellate Court on 206/2025 for further proceedings of the appeal.
9,
Counsel, next time when you come, be better prepared. Don't come up in this manner.
Lordship, extremely sorry.
You're
It
not
is a
fit
nervous
to
matter.
argue about. Yes, Mr. Loskor.
My lord, I am before your lordship with specific instruction, my lord. With the specific instruction of my client, my lord,
You withdraw.
which roll down from the eyes of the petitioner, my lord, I am before your lordship just. My lord, he is a remote corner of the the part affected area, my lord. He will engage one senior advocate, my lord. Kindly fix my lord after Eid, my lord.
What? What is your case?
Case, my lord, is that I am the defendant petitioner before your lordship.
Hmm.
The is a under section 6 of the specific relief act, my lord. The allegation is that I have dispossessed the respondent from the land in question.
Then? You have a stay? No stay.
There was there, my lord.
Stay we vacated? Date.
And my lord,
There has been no, there is no extension of the stay.
yes, lordship,
No.
subsequently it has not been taken.
Then what
Extended.
is that? Records are here.
My lord, only prayer to get a chance, my lord, to them.
Huh?
On my lord, 12th, my lord. May when will be fixed.
Why?
They will engage on one senior advocate, my lord.
What is wrong? When did the person, when did
My lord,
you, what is the allegation?
Allegation is that, my lord, I have disposed the respondent from the city.
When did you dispossess allegations?
As per their, my lord, 9/6/1998.
9/6/1998. Okay. When was the proceedings filed?
Filed within the period of limitation, my lord.
Filed within the period of limitation.
Within 6 months, my lord.
Where is the finding of fact that he was in possession as on that date? Issue number
Paragraph page 6, my lord, paragraph
Number
8. my lord.
3. who proved that he was dispossessed on 9/6/98 and in the instant suit was brought on 1/7/1978. Within one, that's in view of the, so nothing remains, no case.
My lord, there is a purpose, my lord,
dismissed.
quite purpose is there.
Huh? What
Learned
is the perversity?
purpose is that, my lord, the plaintiff PW1, my lord, in his cross-examination has admitted that yes, the defendant, present petitioner is in possession of the suit land.
Obviously, you are in possession because you have dispossessed him.
Before that, my lord, the allegation of
Show me that.
9/6,
Show me that, where did he say that? That he was in
My lord-
possession prior to that?
my lord, while in that, my lord, suit, my lord, I have filed my written statement along with my lord counterclaim. That while deciding the suit, my lord, Larnet Appellate Court, Larnet Court below, my lord, framed issue. That has not been taken into consideration.
Mr. Theolophor, I can do only one favor to you.
My lord.
The favor is taking into account the decision in the counterclaim shall not affect you in filing any other suit based on title. That's the only favor I can do. Because counterclaim should not have been filed in the proceedings under section 6.
My lord, it is by the then Honorable Mr. Justice H. N. Sharma, my lord, in his judgment while demanding back the matter, my lord, he has clearly mentioned that yes, it is maintainable, my lord,
Which one?
counterclaim
In?
in specific, in section 6 of the specific relief act. There is a judgment, my lord.
Then why have you filed here?
My, while remanding.
No, no,
that-
no, your counterclaim is based on title.
Yes, yes, lordship.
So if it is based on title, it's a suit.
Exactly.
So therefore, you have not filed an appeal against that. It's a decree insofar as that is concerned. So
Yeah.
therefore, that decree has attained finality.
Lordship is absolutely right, my lord.
So that decree has attained finality. That means if I hold it, that what you are saying, first of all, in my opinion, there cannot be a counterclaim in the proceedings under section 6. You have a file, you file a separate suit. Because the section 6, it is a very limited scope.
Yes, my lord. Only
Now,
for the-
if you file a counterclaim and the counterclaim which is based on title, and if it is dismissed, it is a suit. And if it is a suit, there is no appeal filed, then you have no title, your title is extinguished. Then
then
you see the ramifications which you are submitting.
Lordship, whatever
Chalo,
your lordship,
Let us dismiss now.
my lord, on my request before your lordship on 12th, my lord, fixed so that they can,
10,000 cost.
my lord,
This court had specifically fixed the matter today for final disposal at the admission stage. The learned counsel seeks for an accommodation and submits that the matter be taken up again on 12th.
Yeah.
Be taken up on 12th as he is not 12th. These are the matters of not 12th, on 13th.
lordship.
Was taking into account that this court had specifically fixed the matter today, the adjournment is granted subject to a cost of rupees 10,000 imposed upon the council, which has to be deposited before this court, before the registry of this court by 11th of June 2025.
My lord,
Full stop. It is further observed that if such amount is not deposited, the matter be listed and the instant deposited by 10th, 11th, 13th, on 11th.
my lord, I am before your lordship, petty council, my lord, before your lordship, if I deposit,
15,
my lord,
make
kindly,
it 15,000. 10,000 is done because you have no case. This type of matters should be finished. It is shameful for this court to say that a matter of section 6 matter is pending for more than a decade. before this court.
My lord, I am.
A person who have been dispossessed in the year 1998 and you have got a decree because
That-
of your counterclaim, the matter got declared. And don't expect this court on that date, he will have a big problem as regards the dismissal of a counterclaim, which I'll obviously observe that your right is gone. And you have not filed an appeal. So you have not filed an appeal against the dismissal of the counterclaim, which will affect you greatly. Tell me. This is a very serious thing which you have done. So if, apart from this 10,000, further bear the consequences on next day.
My lord, then my lord, your lordship may dispose of it.
Fantastic.
Giving my lord that suit, my lord. Observation, my lord.
Now you,
I am under instruction. my
now
lord.
you want to argue on the Justice H.N. Sharma's judgment?
Now I am living before your lordship. my lord.
Don't make that submission.
No, no.
I was doing a favor to you and now you
Exactly, my
want
lord,
that.
exactly. I have understood, my lord. I have only instruction I have.
Okay, this is an application file. Heard Mr. T. Oscar, the learned counsel appearing on behalf of the petitioner. None has appeared on behalf of the respondents on call. The revision and jurisdiction under section 150, who are you? You are appearing for a respondent? What is your name? So and so appears on behalf of the respondent. Full stop. The revision and jurisdiction of this court have been invoked, challenging the order dated,
29/3,
the judgment and decree dated 22/12/2006. Passed in title suit number 24/1998, whereby the proceedings, whereby the suit which was filed under section 6 of the Specific Relief Act 1963 was decreed, thereby holding inter alia that the plaintiff, who is the respondent in the present proceedings, was dispossessed without following the due process, and the suit was filed within the period of limitation. Full stop. This court have duly taken note of the findings of facts so arrived at by the learned trial court, by the learned trial court in a judgment and order decree date in the judgment and order dated 22/12/2006, and more particularly in respect to the discussion so made in issue number
my lord.
which judgment we are concerned.
My
Not,
lord,
not that judgment,
my
this
lord,
one.
80,
On
82.
29 March, 29/3/2016.
Yes, lord.
29.
Page 83.
Have challenged the order dated 29/3/2016, passed in title suit number 24/1998. Full stop. Whereby the suit was decreed and the counterclaim so filed by the defendant number 1 was dismissed without cost. Full stop. It is relevant for the purpose of deciding as to whether this court should exercise its revision and jurisdiction in the instant proceedings. It is relevant to take note of the brief facts which led to the filing of the case. Full stop. The respondent herein the respondent herein, the original respondent herein, as plaintiff, had filed the suit stating inter alia that he is the owner of Schedule 1 core and Schedule 1 core land described in the plaint by way of inheritance, and he was possessing the same since the last 44 years. It was alleged that on 9/6/1988, the defendants all of a sudden trespassed into the Schedule 1 core and 1 core land by plowing over the said land forcefully and removing the southern boundary bracket AIL and merged the Schedule 1A land with the land of the defendant number 1 on the south. It was also alleged that the defendants also merged the Schedule 1 core land by removing the northern boundary bracket AIL with the land of the defendant number 2 on the north and sown osh paddy over the land. Full stop. Under such circumstances, the plaintiff filed an FIR with the Bondukmara police outpost on 15/6/1998 and thereupon filed the suit on 1/7/1998. Full stop. The defendant number 1 contested the suit by filing the written statement and denied the pleadings of the plaintiff and also filed a counterclaim of the suit. He pleaded, the defendant number 1 pleaded inter alia that he was the owner and in possession of the Schedule 1 core land since the time of his father by virtue of purchase by the deed of sale dated 19/10/1938. The answered defendants also preferred a counterclaim along with the written statement for a decree on the counterclaim declaring that the Schedule 1 core land is purchased land of his father. It was also stated that the answering defendants also denied the dispossession of the plaintiff from the Schedule 1 core land from the purchase 1 core land. Full stop. The defendant number 2 also contested the suit by filing a written statement by denying the pleadings in the plaint. In addition to the legal pleas, the defendant number 2 inter alia stated that he had been in possession of Schedule 1 core land since the time of his father, which was within the knowledge of the plaintiffs and others. Full stop. He further stated that the plaintiff, out of his ill will and motive, and in order to grab the lands of the defendant number 1 and 2, had filed the proceedings under Section 145 of the CRPC. Full stop. It was also alleged that the plaintiff had filed a false compromise petition on 24/11/1998 in the alleged miscase number 59/98, stating that the plaintiff number and the defendant number 1 reached an amicable settlement in respect to the Schedule 1 core land. The defendant number 2 denied the amicable settlement and he handed over the possession of the suit land, Schedule 1 core land, in favor of the plaintiff. The defendant number 3 also filed a written statement supporting the claim of the plaintiff. And in addition to that, the defendant number 3 contended that he is the owner of 12 kotha of land in the suit patta as described in the schedule of the written statement. On the basis of those pleadings, as well as the counterclaim, the learned trial court framed as many as 5 issues. Full stop. Had though initially framed 5 issues, but the same were recasted. The recasted issues are as hereindunder, page 85, ABC, 5 ABC. Full stop. On behalf of the plaintiff, 6 witnesses were examined. However, as the PW3 did not submit himself to the cross, his evidence was expunged. On behalf of the defendant, 5 defendant witnesses, including the defendant number 1 and 2, examined themselves along with documentary evidence. Full stop. The learned trial court, while deciding the issue number one, issue number A, কোর্টে লিখিব initially framed 5 issues বুলি কৈছো ন, which are as hereunder. Subsequently, the other following, subsequently, the said issues were recasted as hereunder. তার মানে 4, 1 to 5 প্রথমতে দিয়ে দিব, 5 A, B, C to দিয়ে দিব। হ্যাঁ? The learned trial court, while deciding deciding the question as to whether the plaintiff was dispossessed from the schedule 1.14 land on 9/6/1998. After taking into account the evidence on record, came to a categorical finding that the plaintiff was dispossessed from the schedule 1 core land on 7/8/1998. And 1 colon on 9/6/1998. 7/8, is it 7/8?
7/8 is written, man.
How can it be 7/8? Had come to a categorical finding that the plaintiff could prove the fact that he was dispossessed on 9/6/1998. And the suit having been brought on 1/7/1998 was within 1 month from the alleged dispossession. Yes, madam, how is it possible if you have filed the suit on 1/7? Record actually. As regards the issue number 2, The learned trial court which pertains to as to whether the counterclaim preferred by the defendant number one is maintainable. It was held that a said counterclaim was not maintainable. It was further held that the plaintiff was entitled to get a decree of restoration of possession of the suit land. That is Schedule 1 core and Schedule 1 core. It is further seen that pursuant to the said judgment and decree passed on 29/3/2016, notice was issued and the execution of the order dated, judgment and decree dated 29/3/2016 was stayed till the next date. However, the said stay was thereafter not continued. Heard Mr. T. Uloskar, the learned counsel appearing on behalf of the petitioner. I have heard Mr. T. Uloskar, the learned counsel appearing on behalf of the petitioner, and Ms. So-and-so, who appeared on behalf of the respondents and make their respective submissions. First, this court have duly taken note of the findings were arrived at by the learned trial court. Insofar as issue number one, recasted issue number one is concerned, issue number A is concerned, as to whether the plaintiff was dispossessed from the Schedule 1 core and Schedule 1 core on 9/6/1998 and was entitled to get restoration of possession of the same. The evidence on a record as adduced by the plaintiff witnesses categorically stated that the plaintiff was dispossessed on 9/6/1998. As deduced categorically by all the plaintiff witnesses have categorically stated that they were, plaintiff was dispossessed on 9/6/1998. First. And this aspect, as per the findings so arrived at by the learned trial court, was not challenged in the cross-examination. Rather, the case of the defendants were solely based upon their title. Under such circumstances, this court does not find that there was an error in exercise of jurisdiction by the learned trial court, insofar as the issue number A is concerned, insofar as the decision in the suit so filed by the plaintiff is concerned. This court further finds it very pertinent to take note of that the Section 6 proceedings, proceedings under Section 6 of the Specific Relief Act 1963 are in the nature of a summary proceedings. And the only question involved in such proceedings is as to whether a person who is in possession of an immovable property has been dispossessed otherwise than in due course of law, and as to whether the said suit has been filed within 6 months from the date of dispossession. First. A further perusal of Section 6 also shows, Section 6(3) also shows that there is no appeal provided. There is no appeal or any review provided against such judgment and decree passed in the proceedings under Section 6 of the Act of 1963. The legislative intent in this regard is very clear. However, the learned trial court, while deciding a suit under Section 6, have allowed the defendants to file a counterclaim based on title, which on the face of it was not maintainable. Inasmuch as the court, while exercising jurisdiction under in a suit under Section 6, would not have jurisdiction to decide a counterclaim in respect to the same suit, in the same counterclaim based on title. First, under such circumstances, the decision so made by the learned trial court in respect to the maintainability of the counterclaim is required to be interfered with in as much as it was in excess of its jurisdiction. First, consequently, this court therefore disposes of the instant revision application with the following observations and directions. This court the judgment and decree so passed on 29 wait, 2016 in title suit number 24/1998, insofar as decreeing the suit in favor of the plaintiff is does not require any interference. Number two, the judgment and decree dated 29/3/2016 passed in the counterclaim filed in title suit number 24/1998 is interfered with only on the ground that the said court did not have the jurisdiction to adjudicate the said counterclaim. First, number three. In view of the observations and opinion expressed in clause Roman 2, comma, upon due execution of the decree passed in judgment and decree passed in title suit number 24/1998 and thereby handing over the possession in favor of the plaintiff the legal representative and the respondents who are the legal representatives of the plaintiff, comma. It shall not be a bar upon the respondents, the petitioners herein, to file a suit based upon title for recovery of possession.
Oblige your lordship.
Cost, taking into account that for the last decade, almost a decade, the plaintiffs have been deprived from, last almost 1998, 3 decades, the plaintiff have been deprived from the possession, comma. This court dismisses the instant proceedings with a cost of 30. Very challenging.
Judgment and order dated 4/06/2024 passed by Learned Civil Judge, Division, Junior Division 2, Jorhat.
Good. Possessed on Suit filed on? Suit filed on? Where is your senior?
Lordship, he was suffering from fever, Lordship.
Yes, when was the suit filed? Mr. Counsel? Suit filed, Lordship. One six. And when was he dispossessed? Twenty-two, 2016. 1/6, 2016 filed suit. The council, there is no clear finding that the plaintiff was in possession. That is okay, but where is the finding in the, while deciding the issue number 5? Let me come here to paragraph number 35. Further, the plaintiff stated that the defendant also constructed a brick wall and enclosed the suit land. From the cross-examination of defendant number 1, it revealed that there is a boundary wall on the entrance of the Kendra, and on the other side there was no wall. Later, it is also stated that on the 3 sides there were tin barricades. Further, the defendant stated that after the demolition of the shop of the plaintiff due to acquisition, they constructed a brick wall on the direction of the shop. Therefore, one thing has come to light that there was no clear boundary of the Kendra on the direction of the shop prior to the dispossession of the plaintiff. The plaintiff has asserted that he started construction on the suit land, which was in his possession, but the defendants demolished those and erected a brick wall. The defendants has also stated that after the construction of the brick wall, the material of construction will remain on either on their side of the wall. As there is no clear boundary between the plaintiff and the defendant land, it cannot be ascertained that the defendant was in possession of the suit land. Hence, from the evidence, it is gathered the plaintiff was in possession. What is this? And the defendant's specific case is, once the land has been acquired, nothing remained. In fact, half of the plaintiff's house was, shop was demolished. That is your witness also. Half was there and the remaining the plaintiff demolished. How much it was there? That is not a finding is there. Do you have any title over the land?
Paragraph 16. First issue related to the question of cause of action. The plaintiff for filing on the suit cause of action is the bundle of the fact released by one side and denied by the other. File for expression of 1.5 above land instead of 1.5 as mentioned in the LD. Yes, permitted that the defendant immediately disposes it without showing due process of law. On the other hand, that the plaintiff was in possession of 1.5 and he was running his business establishment, the government required all of his land for construction of national highway.
No, this is for cause of action. I am not on that. But we are concerned was issue number 5. Now the issue number 5, it is not clear. Understood, I've read it. Now kindly see your evidence, PW, what does PW2 say? Page 41. In his cross-examination, denied the suggestion put to him that the plaintiff was not residing in 1.5 kathas of land and that he took bookshop was only 1.5 lechas. And PW3 stated that in his cross-examination that the plaintiff received compensation for acquisition of the land by the government. Because you yourself say that you were not in possession of there because 16 lechas out of 1.5 kathas was already taken. 1.5 kathas, 1.5 kathas would be 25. Wouldn't be?
As per my knowledge.
No, therefore, here in his own case, he says, kindly come to this, paragraph 6, page 30. On demand, the plaintiff started the process of construction of a business on the remaining land measuring 16 lechas, which is the Schedule B land. Now kindly see PW4 says, stated in his cross-examination that the plaintiff had a shop and he used to in his shop and the plaintiff received compensation for acquisition of land. Next, with the PW3 wrongly numbered as so-and-so stated in his cross-examination that half of the shop of the plaintiff. Because what the plaintiff says is that he had 1.5 kathas, of which 14 lechas went and 16 lechas remained to him, wherein he constructed the shop. Okay. Now kindly see what at paragraph 32, what he says. That in his conclusion that half of the shop of the plaintiff was acquired by the government, meaning thereby what the plaintiff says in his case is that in that 16 lechas of land, which is the Schedule B, he constructed after the acquisition. Yes, kindly see paragraph 30, page 30. Paragraph 6. Yes, paragraph 6.
Therefore, on or above 29 said none, the plaintiff stated the process of construction of his business on the remaining land measuring 16.
Which is the subject matter. So you constructed the business premises on these 16 lechas. Whereas your own witness says that while acquisition was carried out, half of it was broken. Kindly see this. Therefore, I am saying page 32, paragraph 32. And kindly find the finding at paragraph 33. Hence, from the evidence and the cross-examination of the plaintiff, it is evident the plaintiff had a shop in the suit land and one part of his shop was acquired by the government, meaning this acquisition happened subsequently. So not what the plaintiff stated. And the other half remained with him, which he himself demolished. Paragraph 33, page 42. And now, kindly see your deed of sale, what the plaintiff says in his cross. Exhibit 2 mote, মোৰ দেউতাই 1.5 লেচা মাটিৰ বাদ দি সমগ্ৰ মাটি ডিফেন্ডেন্ট নাম্বাৰ 1ক বিক্ৰী কৰিছিল। এই বিক্ৰী 2000 টকাত হৈছিল। This is your cross. Then what remains? We had a half lesser, 1.5 lesser. You did not go for rectification of that deed. So only left was 1.5 lesser. You have got 14 letters, you have got acquisition amount for 14 letters, you should have been more happy with it. How? How?
Agreement of the total land is
Understood, how? Because your exhibit two.
I have possessed 1.5.
No. Exhibit two was the document
What?
by which you also said that your father sold it.
Loss of value.
Huh?
Exhibit loss. 6 loss.
Hmm.
Exhibit 6 loss. Exhibit 7 loss. 7 is the circle of the loss. Stating that the father of the place is in possession of the 1.5 kata land covered by the number 20. This document is dated.
Who says?
Exhibit 7 loss. Circle of the loss.
PW seven. Mandal is PW. Yes, PW five.
Losses for page 40 losses.
PW five says দেউতাই ডিপেন্ডেন্টৰ মাটি বিক্ৰী কৰা মই এম ই স্কুলত পঢ়ি আছিল বিক্ৰী দলিলখন মই পোৱা নাই দলিলৰ মতে মাটি বিক্ৰী কৰা No, the court has to come to a categorical finding. What does it say? What is it? Which paragraph?
Paragraph 50 losses.
Paragraph?
Paragraph 16 losses.
That I read it. 20, what does it say? How is it relevant?
Under section 6 of the Aesthetic Relief Act.
That I read it. Now come to paragraph 20, what is there?
20 losses in a situation where the learned trial for some consideration of the respective case of the party and the document left before it was one of the views that the entitled And of the plaintiff to an order of interim mandated injunction was in serious doubt. The appellate court could not have interfered. How does it relevant?
First of all, without a specific finding of fact that he was in possession of that. What is this? You have a title, go and file a suit for title. You don't have a suit for the based on title. Your own specific averment is that only 1.5 lesser was left. Then no case. Chalo. Heard Miss So and so, the learned counsel appearing on behalf of the petitioner. Comma. Mr. So and so, who appears on behalf of the respondent. Number. One. None appears on behalf of the respondent number two.
I am agreeing. One and two.
One and two. How is two irrelevant? Who filed the suit? One.
One and two.
Both filed.
Two is the.
No, suit was filed only one. Why you are paying for two? Two had died. Manik Dotto. Dilip Dotto. For respond number one and two. The revisional jurisdiction of this court have been invoked to challenge the order dated judgment and decree dated 4/6/2024, passed in title suit number 20/2011, 2021, whereby the learned court of the civil judge junior division number 2 at Jorhat, hereinafter referred to as the learned trial court, had decreed a suit under section 6 of the Specific Relief Act 1963 in favor of the plaintiff. First, the revisional jurisdiction under section 115 of the code have been invoked on the ground that the learned court of the so and so, trial court will the learned trial court had exercised its jurisdiction illegally and with material irregularity. And as such, this is a fit case for exercise of the revisional jurisdiction. Ms. So and so, the learned counsel appearing on behalf of the appellant petitioner submitted that taking into account that the proceedings under section 6 of the SR Act, SR Act of 1963, SR Act is limited to ascertaining as to whether the plaintiff was in possession of the suit land, a possession, and whether he was dispossessed otherwise in due course of law. The learned court below ought to have come to a categorical finding that the plaintiff was in possession of the suit land on the date of his dispossession, alleged dispossession. The learned counsel submitted that in the instant case, the findings of fact so arrived at an exhibit number 5 in issue number 5, the learned court below was not certain as to whether the plaintiff was actually dispossessed. And on conjectures and surmises arrived at the finding that the plaintiff was dispossessed. It is therefore submitted that this is a fit case for interference. Per contra, the learned counsel appearing on behalf of the respondent, number 1 and 2, submitted that the plaintiff was in possession of 16 letters of land, which was the Schedule B land, and the learned court below had rightly interfered and rightly passed the said judgment. The learned counsel further submitted that in the instant case, the findings of facts so arrived at on the basis of the evidence would clearly show that the plaintiff was in possession of the 16 lectures of land when the defendant on 22/2016 had dispossessed. Taking into account the respective submission, this court finds it relevant to take note of the brief facts which led to the filing of the instant proceedings. First, the plaintiff
Whether there is any paragraph 16 already stated.
Let me now come. I put your submission that he was in possession of Schedule B land. The respondent number 1 as plaintiff had stated that the father of the plaintiff purchased a plot of land at measuring 1 biga 4 kata 6 lechas and half lesser, 6.5 lesser, covered by PP number 57 old 02 new, tag number 397 old 3233 new in the year 1956 by the registered sale deed number 1612 dated 3/5/1956 and was in possession of the said land by constructing a kacha house in a part situated by the side of the 80 road and used to carry out a business of books and stationery in the said house with bamboo fencing around the part. On account of his health problem, the father of the plaintiff had executed the deed of sale bearing deed number 90 dated 10/1/1961. Thereby, the entire land was sold, keeping only 1.5 lechas as unsold land. It has been alleged that it was inadvertently mentioned as 1.5 lecha. It should have been 1.5 kata. Be that as it may, the said 1.5 kata of the land, however, remained in possession of the plaintiff, which has been specifically described in Schedule A to the plaintiff. It has been further alleged that a part of the Schedule A land was acquired by the government to the extent of 14 lechas of land. Under such circumstances, 16 lechas of land, the remaining 16 lechas of land, which is the Schedule B land, was in possession of the plaintiff. The plaintiff on or about 29/10/2015 started construction over the Schedule B land. On 3/11/2015, the defendant, the plaintiff, erected a pakka post in the suit land and stored business material for construction. However, the defendant number 2 and 3 raised objection, which led to a proceedings under section 107/145 of the CRPC, and there was a direction to maintain status quo of the suit land on 2/3/2016. Be that as it may, on 28/1/2016, the defendants entered into the suit land and demolished the construction of the plaintiff, and on 22/2016, the defendant constructed the brick wall encroaching the suit land and dispossessed the plaintiff from the suit land. It is under such circumstances that on 1/6/2016, the plaintiff filed the suit under Section 6 of the Specific Relief Act, claiming recovery of possession on the ground that the plaintiff has been dispossessed otherwise from the Schedule B land, otherwise in accordance with law. First, on behalf of the defendants, they filed a written statement wherein various grounds were alleged, various preliminary objections were raised. It was a specific case of the defendants that the deceased father of the plaintiff was the owner of 1 bigha 4 katha 16.5 lechas of land, out of which the father of the plaintiff sold 1 bigha 4 katha 15 lechas of land to the defendant number 1, and the remaining land of 1.5 lechas was kept by the father of the plaintiff for his business purpose. And the plaintiff was running a shop thereon. After the purchase, the possession of the land was also handed over to the defendant number 1, and the defendant number 1 had been regularly paying the necessary land revenue. It was further stated that the land measuring 1.5 lesa, which was owned by the plaintiff, was acquired by the National Highway Authority, and as such, for having some wrongful gain, the plaintiff had cooked up the story. Full stop. On the basis of the pleadings, as many as 7 issues were framed, which are reproduced hereunder. First, on behalf of the plaintiff, 6 witnesses were examined and 7 documents were 6 witnesses were examined and 7 documents were exhibited. On behalf of the defendant side, 2 witnesses were examined and 3 documents were exhibited. The issue number 5, so framed, is of vital importance, taking into account the scope of the proceedings. Issue number 5 related to as to whether the plaintiff had been in possession for 6 months prior to the institution of the suit. First, the learned trial court, after going through the evidence on record, arrived at its finding, which is at paragraph number 35, which, being relevant, is reproduced hereunder. On the basis of the said observations so made at paragraph number 35, the learned trial court had decreed the suit in favor of the plaintiff, and it is under such circumstances the present proceedings have been filed. Have decreed the suit in favor of the plaintiff by the judgment and decree dated 4/6/2024, and it is under such circumstances the present proceedings have been filed. In the previous segments of the instant judgment, this court had duly mentioned the submissions so made by the learned counsels appearing on behalf of the parties. This court have also perused the evidence on record and the evidence from the lower court reports in title suit number 20/2021. First, next. It is very pertinent to take note of that the proceedings under Section 6 of the Specific Relief Act is a summary proceedings with an object to afford an immediate relief to an aggrieved party to reclaim possession of which he may have been unjustly denied by an illegal act of dispossession. The questions of title or better rights of possession does not arise for adjudication in a suit under Section 6, where the only issue required to be decided is as to whether the plaintiff was in possession at any time 6 months prior to the date of filing of the suit. The legislative intent underlying Section 6 of the Act of SR Act is to provide a quick remedy in a case of illegal dispossession so as to discourage litigants from seeking remedies outside the arena of law. And this very aspect of the matter can be seen from a reading of Section 6(3) of the SR Act. First, under such circumstances, taking into account the facts involved, the question which was required to be addressed by the learned trial court was as to whether the plaintiff was in possession of the Schedule B land on 28/1/2016 when he was dispossessed. First, this court, in the previous segments of the instant judgment, have quoted paragraph number 35 of the judgment passed by the learned trial court, which pertain to issue number 5. First, the learned trial, it is seen from that the learned trial court, while recording the evidence, while taking into account the evidence on record, and coming to the conclusion, would not come to a specific finding to the effect that the plaintiff was in possession of the suit land on 28/1/2016, on the date on which it was alleged that the defendants entered into the suit land. First, taking into account that the proceedings are summary in nature, the findings that the plaintiff was in possession on 28/1/2016 and he was dispossessed was on 2016 and he was dispossessed was on so and so. It's a finding which is to be arrived at clearly by the learned trial court to grant the benefit under Section 6 of the SR Act. The findings of the learned trial court being not clear on this aspect, it is the opinion of this court that the learned trial court failed to exercise its jurisdiction, had exercised its jurisdiction illegally and with material irregularity. Considering the above, this court therefore interferes with the judgment and decree dated so and so, dated 4/6/2024, passed entitled suit number so and so. And the said judgment and decree is set aside and quashed. First of the records be returned back to the court. First of, the dismissal of the dismissal of the suit, the setting aside of the judgment and decree, and the consequent dismissal of the suit by this court by the present judgment and order shall not preclude the plaintiff to file a suit based on title.
Yes, my lord.
Item 11.
Yes, Ms. Sakia. What are you challenging?
It's a small causes court that it has arisen from.
Huh?
The matter
Oh,
was
your
in,
case. I remember giving him the right to file. Isn't it? Giving him the right to file in a summary proceedings.
Summary proceedings.
Isn't that the issue?
So it's just the WS. WS is the issue. So there should not be a WS. Small causes court has never had WS. WS has 30 days going on to 90 days. And small causes court 10 days leave of defense based on very, very valid grounds. Like if whether all the amount had been paid and it was not paid, there are certain amounts due.
Where is the judgment on this point?
And last page, the one that we are challenging, 40, page number 39.
No, that I've seen it.
Yes.
Where the Supreme Court had dealt with this aspect.
This, yeah. Whole thing there.
Yes, what are you referring to?
There are, so it's rule
Both
three.
are relying on the
Rule
same
three.
judgment.
Yes.
You gave this.
No, it's part of our things as well.
And
It's just
both
that
are why?
page
One
number
is
two-
an SCC, one is a Supreme Court. means-
Because this is the original thing that used to be printed in Supreme Court earlier. And this was downloaded from their website long time ago. So
Chalo,
just
we hear you again at 2 o'clock.
at 4 o'clock,
2 o'clock.
2 o'clock.
Where's your plane?
The plain. The claim and the additional affidavit. Page number
You are challenging 3011. You're challenging 3011 2023.
3011 to the point of the WS as well. And there is a cross-examination, thereafter it proceeded to cross-examination as page number 41. The review after cancellation of the
But
review,
without seeking a leave, written statement has been filed.
written statement was filed.
Understood. But did you seek a leave? Did you seek a leave? Well, serve with a copy means?
Every, was it all, served, because the court had itself sent it. All the copies are always, notices are all served with the plinth and the annexes.
No, whatever may be. But the moment you were served, when did you come to know? 10? Ten, 11, you came to learn. Then did you seek a leave? Then where is the question of filing written statement? Huh? You have to seek a leave and giving good reasons that you have a tribal issue. Then only you can file a written statement. Without the leave, where is the written statement question? Hmm. 3011. Hmm. Where is the document? Annexure?
9, Annexa 8, Annexa 8. Page 71.
All are understood, but without seeking a leave, how can you file written statement? Written statement cannot be accepted. So what are you challenging, madam?
No, there is a procedure for appearance of the defendant in Rule 3.
Impugn order dated 6/3 today rejecting the
Yes, that
review
goes to-
petition and the impugn order dated allowing the written statement. Okay. Third miss,
Yes, I can.
Ezekiel, the counsel appearing on behalf of the petitioner, Mr. So-and-so, who appeared on behalf of the respondent, opposite party. Pusto. The the supervisory jurisdiction of this court have been invoked to challenge the order dated 30/11/2023 passed in summary suit number 10/2023, as well as the subsequent order of rejection of the review petition dated 6/3/2024. Full stop. The learned counsel appearing on behalf of the petitioner submits that taking into account that the suit was filed in terms with order in a suit was filed coming within the ambit of order 37, comma, without seeking a leave to defend, comma, the question of permitting the defendant to file a suit, file a written statement is completely is beyond the provisions of order 37. In that regard, the learned counsel referred to the judgment of the Supreme Court in the case of Southern Sales and Service and others versus SAURMILTH, Design and Handles GmbH, reported in 2008-14 XCC 457. Per contra, the learned counsel appearing on behalf of the respondent submitted that the respondent oblique defendant did not receive the copy of the summons, and as such sought for vacation of the order dated 4/11/2023 by filing an application under Order 9 Rule 7, which was registered as Miss Case number case number 496/2023. The learned counsel submits that this application was allowed by an order dated 30/11/2023. And thereupon, by another order passed in the suit, the next date was fixed on 15/12/2023, and on the basis thereof, the written statement has been filed. The learned counsel appearing on behalf of the respondent further submitted that taking into account that the court had permitted filing of the written statement, comma, it would amount to granting of a leave by the court, and as such, the written statement ought to be accepted. Full stop. This court, upon hearing the learned counsels appearing on behalf of the parties, finds it relevant to take note of the provisions of Order 37, Rule 7, 37 of the Code. Full stop. A perusal of Order 37, Rule 1(2) stipulates what suits comes within the ambit of the order. First, It includes suits. Your suit is for what?
On a written contract
It includes suits
to be.
in which the plaintiff seeks only to recover a debt or a liquidated demand on money payable by the defendant with or without interest arising on a written contract. First, this court further finds it relevant to take note of the suit which was filed by the petitioner, which is based upon a agreement dated 25/1/2018. And the plaintiff and the petitioner as plaintiff claiming an amount of rupees 1,37,000 along with interest at the rate of 12% per annum. Justo. This court further finds it relevant to take note of Rule 2 of Order 37, which stipulates the manner in which a summary suit is required to be instituted. It further stipulates that a summons in respect to a summary suit has to be issued in Form 4 in Appendix 3 or in such other form as may from time to time be prescribed. Subrule 3 of Order Subrule 3 of Order 37, Rule 2 further stipulates that the defendant shall not defend the suit referred to in Subrule 1 unless he enters an appearance and in default of his entering into appearance, the allegations in the plaint shall be deemed to have been admitted and the plaintiff shall be entitled to a decree for any sum not exceeding the sum mentioned in the summons, together with interest at the rate specified, if any, up to the date of the decree, and such sum for cost as may be determined by the High Court from time to time by the rules made in that behalf, and such decree may be executed forthwith. Rule 3 of Order 37 further stipulates that the defendant upon being served a copy of the plaint and the annexures thereto, at any time within 10 days from such service, enter an appearance, either in person or by pleader, and in case he shall file in the court an address for service of notice on him. First, Subrule 5 of Order 37, Rule 3 is of importance for the purpose of the instance proceedings for which the said Subrule 5 of Order 37, Rule 3 is reproduced hereunder. From a perusal of the third rule, Subrule 5, it is seen that the defendant may at any time within 10 days from the service of the summons for the judgment, by affidavit or otherwise disclosing such facts as may be deemed necessary sufficient to entitle him to defend, apply on such summons for leave to defend such suit, and leave to defend may be granted to him unconditionally or upon such terms as may appear to the court or judge to be such. But did you carry out this sub-rule 4?
Yes, sub-rule 4 was carried out in the sense.
Did
when-
you serve, shall thereafter serve on the defendant a summon for judgment in form 4A?
Yes. No, what happened was, we already, the day he appeared, we already completed our evidence stage. The day he appeared, the
No, no, no,
evidence stage
no.
was completed.
So therefore,
this
no,
was already-
understood. But the moment an order 9.7 application is allowed,
Yes,
it dates back to the date on which the court had proceeded ex parte.
Yes.
That is on 4/11.
yes.
So therefore, on that day, did you serve the form 4A?
Form 4A was ready and they had come.
Did you serve? I'm asking.
It was given. That's
Did
all.
you serve it upon the plaintiff,
The
defendant?
the defendant didn't come. It was given to the, on
No,
the file.
you served 4.
It was given on the file,
Served 4. Form 4.
form 4.
But what about 4A?
So, form 4 and 4A were together provided in the file because they didn't come at the same time as us. So it was just left in the file.
No, no, my
the time.
question therefore is specific to you. Did you serve the form 4A upon the defendant? Because
Left in the
5
file.
will come,
Yes,
5
5
will
will
come
come, provided he is
within
given the
10 days from the service of such summons for judgment, means for 4A.
So,
Form 4A is the judgment, yeah, for judgment.
yes. So, but we were in the evidence stage. And
No, I am asking you, the
Yes.
day on which it goes back to the stage of 4/11.
411.
The
The
court,
day-
the
the day
court
ex parte
vacate,
order
the
was
court
filed.
vacated the order on 30/11,
on 3011,
and therefore it goes back to 4/11,
411.
4/11. So did you on that day serve 4A?
We left it in the file, not on 3011. Earlier, the day it was meant to be, the day he was meant to come, I think it was 10/11, and that is the day we had left it in the file.
No, no, 4A is a judgment. You see, see the form.
Yes,
Upon reading the affidavit of the plaintiff, the court makes the following order, namely, let all parties concerned attend the court on the so and so, so and so, so and so, along with interest. So, did the court pass this order? Sign the form?
No.
The court having not done so, then he still have a right for defense, seek the leave for defense.
yes, and that is seeking defense is not we are challenging. We are challenging.
So
the fact-
therefore, the question is,
Yes.
we can put the stage back to that stage where he can file his application seeking leave to defend.
Leave to defend.
So
Yes.
therefore,
Yeah.
that we put the suit to that stage.
We can put that suit to that stage.
That is,
Our main objection is
Yes,
only
yeah.
written statement and
it is
cross-examination.
relevant to take note of. Sub-rule 4 and 5 of rule 3 of order 37 of the code. And as such, the same are reproduced hereunder. A perusal of the said above quoted sub-rules would show that if the defendant enters on an appearance, the plaintiff shall thereafter serve on the defendant a summons for judgment in form 4A in Appendix B, or such other form may be prescribed from time to time, returnable not less than 10 days from the date of service, supported by an affidavit verifying the cause of action. and the amount claimed and stating that in his belief that there is no defense in the suit. Full stop. Sub-rule 5 of Rule 37, or Rule 3 of Order 37 further gives a right upon the defendant at any time within 10 days from the service of summons for judgment by affidavit or otherwise disclosing such facts as may be deemed sufficient to entitle him to defend, apply on such summons for leave to defend such suit, and leave to defend may be granted to him unconditionally or upon such terms as may appear to the court or the judge to be just. Full stop. At this stage, let this court now take note of. Full stop. This court further finds it very pertinent to take note of Form 4A of Appendix B. Appendix B, na?
Appendix B.
Appendix B, which, being relevant, is reproduced here in under. Itu ekone CPC pabote Appendix B. Full stop. In the backdrop of the above, let this court now take into consideration as to how the summary suit number 10/2023 proceeded. Full stop. The suit was filed in the month of July 2023, 7th of July 2023. Full stop.
Tenth
There-
of July.
Huh?
Okay, 10th of July
10th of
2023.
July 2023. Full stop. It is seen that on 4/11/2023, the learned court of the Civil Judge Junior Division number 1 Kamrup Metro at Guwahati had passed an order indicating that the summons issued upon the defendant returned after being served, and as the defendant was absent without steps for which the suit shall proceed ex parte against the defendants, and accordingly fixed 10/11/2023 for evidence. Full stop. On 10/11/2023, the defendant appeared and filed an application under Order 9 Rule 7 of the CPC for vacating the ex parte order dated 4/11/2023 on the ground that summons were not served upon the defendant, isn't it?
There's no grounds like that. No?
Summons were served but without documents, without the plaint as well as the other documents. The record further reveals that the said application filed under Order 9 Rule 7 of the court was taken up, was registered as Mizje case number 496/2023. The learned trial court, by an order dated 30/11/2023, found that the cause shown in the application filed under Order 9 Rule 7 was a good cause, and accordingly vacated the interim order, vacated the ex parte order, and vacated the ex parte order. Full stop. The effect of allowing the application under Order 9 Rule 7 of the code, in the opinion of this court, relegates the suit back to the date on which the defendant did not appear. Full stop. Thereby, the suit gets relegated to the date of 4/11/2023. Full stop. It is however seen that by another order dated 30/11/2023 in the suit, the learned trial court fixed the for filing of the written statement on 15/12/2023. In the opinion of this court, the learned trial court could not have done so, taking into account that without seeking a leave to defend in a suit filed under Order 37, the filing of the written statement by the defendant does not arise, as would be apparent from a perusal of Order 37, Rule 3, bracket 4, Subrule 4 and 5 of Order 37, Rule 3 of the code itself. Be that as it may, the written statement thereupon was filed. On 15/12/2023. First, the petitioner herein filed a review application seeking review of the order dated 30/11/2023. And by an order dated 6/3/2024, the learned trial court dismissed the said review application, and it is under such circumstances the present proceedings have been filed. First, in the opinion of this court, this court further, while hearing the matter, inquired with Ms. A. Saikia, the learned counsel appearing on behalf of the petitioner, as to whether, upon appearance of the defendant, upon the order being passed on 30/11/2023 in Ms. case number 496/2023, thereby relegating the suit back to the stage of 4/11/2023, whether any summons for judgment in Form 4A in Appendix B, as quoted herein above, was served upon the defendant, taking into account that the right of the defendant to file the seek the leave to defend only accrues when such a summons for judgment in Form 4A of Appendix B is served upon the defendant. The learned counsel appearing on behalf of the appellant petitioner submitted that no such form have been served upon the defendant.
Left it in the file. So we left it in the
How
file.
can it be left? It has to be signed by the court.
That didn't happen
So therefore,
because this
was not served, taking into account that the court did not take any steps for signing the said Form 4A, the summons in Form 4A. First, from the above discussions, it would therefore be clear that the learned trial court have proceeded with the summary suit in a manner which is similar to a normal suit. And as such, it is the opinion of this court that the supervisory jurisdiction of this court is required to be exercised, taking into account that there is a complete error on the part of the learned trial court in proceeding with, in exercising its jurisdiction. First, further to that, it also shocks this court that the learned trial court did not adhere to the provisions of Order 37 in the manner stipulated in the rules, and proceeded the suit in such a casual manner. Considering the above, this court therefore disposes of the instant petition with the following observations and directions. Number one, the written statement so filed by the defendant defendant in the suit in the summary suit number so and so, though have been filed, would not be accepted by the court. Well, be the order by which the order dated 30/11/2023, as well as by which the learned trial court directed fixed 15/12/2023 for written statement is interfered with. Next, the order dated 15/12/2023, by which the written statement filed by the defendant was accepted, is interfered with. Number 3, comma. It has been submitted by the petitioner oblique the plaintiff that the forms the summons for judgment in form 4A have already been submitted before the court, comma. The learned trial court is directed to consider the said form and issue the same and serve the same, issue the same. Is directed to issue the said summons, consider as it has been submitted by the learned counsel for the petitioner, oblique the plaintiff, that they have already filed the summons for judgment in form 4A, and the same is on the record, comma. This court directs the learned trial court to issue the same and serve a copy upon the defendant in the suit. Full stop. It shall be open to the defendant thereupon to file appropriate application seeking leave in terms with sub-rule 5 of Order 37, Rule 3. Full stop. Basing upon the decision taken basing upon the decision so taken by the learned trial court to grant the leave or not to grant the leave, the learned trial court shall further proceed with the adjudication of title suit number so and or commercial suit number so and so. Full stop. It is seen that by the order dated 24/2024, the further proceedings of summary money suit number 10/2024 23 pending before the court of the learned civil judge junior division number 1 Kamrup Metro was stayed. The said stay order stands vacated and the parties are directed to appear before the learned trial court, the said court, and on 23rd of June 2025 for further proceedings of the suit.
Much.
Time being motion item 6.
Yes, Mr.
Lord, your lordship possibly asked me about section 30. And
Go there.
in terms of that, my lord,
It becomes difficulty. It becomes a very difficult proposition. Against the recovery officer, better off we go to the presiding officer.
your lordship is very right, maybe only section 14 of the Limitation Act, your lordship can be observed. So there will be some delay.
I can only give you this time only for days because when you move this court, You filed only on 22/5, but the period has expired on 22 to 28. How do I help you? You have to file an application for condonation of delay is permissible.
That will have to be filed, my lord. But then if your lordship observe section 14, that will facilitate me, my lord, convince them.
Section 14, if I give you only from, how many days I will give you? That is only from 22/5. You have to file within 30 days.
Within 30 days.
Then the period is over on 28/2,
Yes.
28/3. So I only give you 10 days. That's all. But that makes no sense.
10 days, my lord, it will have.
It
no
doesn't
sense.
make any sense. So therefore, okay. The petitioner herein have assailed the order dated 28, heard Mr. S. Dotto, the learned senior counsel, appearing on behalf of the petitioner. So the petitioner herein have also challenged the order dated 28/2/2025, passed in. What is the number?
At page 106. my lord,
Passed
same
in OA number. OA,
time. Oh, yes,
OA number
98 of 2018.
98/2018, arising out of RC number 96/2022.
And another.
And OA number 99/2018, arising out of RC number 66/2022. This court duly takes note of that the said order is being passed by the recovery officer of the Debt Recovery Tribunal. Full stop. This court further takes a perusal of section 30, na,
30.
of the recovery of debts. What is that act name?
Recovery of Debts and Bankruptcy Act 1993.
No, it's shorter name. Recovery of Debts and Bankruptcy Act 1993 shows that against an order passed by the recovery officer, an appeal lies before the
The tribunal.
to the tribunal, to the Debt Recovery Tribunal. Under such circumstances, this court is not inclined to entertain the instant proceedings when there is an alternative and an efficacious remedy available to the petitioner. The learned counsel appearing on behalf of the senior counsel appearing on behalf of the petitioner, though submitted that the said remedy now cannot be said to be an efficacious and alternative remedy, taking into account that the period of limitation for assailing an order is 30 days from the date on which a copy of the order was issued to him. It is the opinion of this court that as the Debt Recovery Tribunal has the power to condone the delay, the same cannot be said to be a ground for entertaining the present proceedings. Accordingly, the instant matter stands. I gave you that whatever.
Item 43 fixed at 2 p.m.
Filed by the claimant itself.
Mr. Gusami, you got that order? Actually, so many orders were done, so all these times were typed out and it was given in those. That I know. But it was under attachment when you passed that order. I passed that order also. Anyways, tell me, what is this?
This is enhancement lordship for filed by the appellant claimant lordship. That only lordship expenditure was 2,28,886 and judgment was just given 2,40,000. And he suffered 40% permanent disablement lordship.
So as per you, how much it should be?
From my calculation lordship, it should be 24,70,000.
So that is less 40,000, almost 40,000.
No lordship.
Because the court has given 1,86,000
Lordship,
out of 2,28,000.
lordship.
That is one. The second,
And lordship, he suffered 40% permanent disablement lordship. This in exhibit 47 is there. And he was working as manager in a hotel lordship. That was also that hotel, one manager of the hotel was also examined before the court tribunal lordship.
a manager in the hotel is getting 5,000.
Lordship in 2009. 2009 lordship, this is
He is said to be in charge, not
lordship.
manager. Now what is he doing?
Now he is bedridden lordship. After that accident, he suffered accident and 4-5
Huh?
4-5 operations was operated in his legs, and now after that he paralyzed and he was now bedridden lordship from today's news lordship.
But you have not filed any additional evidence.
Lordship. Well,
Have you filed any additional evidence?
before tribunal, no lordship. That-
Here,
No lordship.
then let us not talk about those.
Then also lordship. Yes.
Now, why 1,40,000 has been given? Mr. Goswami,
2,40,000 only.
understood, 1,86,000 was found as medical. But why only 40,000, 2,40,000 then it is, given? Only 60,000 is given? Huh? Yes, but why? There's no reason, nothing has been mentioned. Find and hold that the claimant used to earn 5,000 per month. Has failed to establish that he suffered any permanent disability due to the accident.
Lordship.
You did not produce any document.
Lordship, we have produced a board that physical disability certificate, 47 lordship exhibit.
Huh?
Exhibit 47 lordship.
Oh, I don't know. I got to do. So how much it should be?
It should be lordship 24,72,000 lordship. 24,72,000 lordship.
Why? You are asking for 14 lakhs, now you are asking for 24
No,
lakhs?
lordship, this is at that point of time we have asking, but now this man was totally disabled.
Huh?
Totally bedridden lordship.
Now I can't help you. I'm only asking you then.
But
I'm
lordship
on
can-
appeal.
But lordship can enhance it.
I can enhance it, but taking into account what happened there.
Lordship, may I
How
just,
much?
may I just point out lordship? Medical expenditure lordship, 2,28,886 lordship. His loss of future income is lordship, he was working as 5,000 his income. And lordship, he was totally unable to earn anything lordship, as shorten was there. And for that lordship, 2,000 for future loss of income.
Huh?
40% for future loss of income.
What was his age?
32 lordship at the time of accident lordship.
The future prospects, he gets it how much?
40% of the income lordship. 40% of the income lordship. As per prononced judgment lordship.
Provided in what? Which case?
Prononced lordship, the national insurance is pronounced para 61 sub para 4 lordship.
Show me that. Exhibit?
Exit 47 lordship. Is disability.
One seventy. This is to say, this is a proved in original. What is this I-card?
Social welfare department.
Huh?
Social welfare department lordship.
Exhibit 48.
40 lordship.
48.
40% lordship.
What is
Exhibit
it?
47,
Exhibit
47 lordship.
47? 47 is different. 47, where do I get it?
47 and 48 lordship.
47 and 48. 47 it is. 48.
Right.
Proved in original. Okay, what does it say?
Nature of disability post-traumatic deformed and shortening of right lower limb with muscle weakened non-functional lordship.
So how much is the disability mentioned?
Its disability is 40%.
Post-traumatic deformed and shortening of the right lower limb with muscle weakened, non-functional. Huh? List of expenditure towards treatment. The leg got shortened. Yes, how much it should be? Show me any judgment, how much, how it is to be calculated?
2011 regarding disability lordship 2011 judgment. Rajkumar.
Huh? Beg your pardon? Yes, yes, please. Here there is, here the exhibit 48 is the disability, not the certificate, but it is a disability card.
Card.
Card which has been given to him. Social Welfare Department. So there he says that this is the, what has happened. So therefore, no doctor, but whatever may be,
Disability board. No. Disability disability.
it have acted with person if you But in this paragraph, very relevant, if the tribunal is not satisfied with the medical evidence produced by the claimant, it can constitute a medical board from a panel contained by it in consultation with reputed so and refer the claimant to such for assessment of the disability. But the fact that when he was disabled, this certificate, he is not satisfied with that. He has, I don't think he has referred it in his judgment note. No, I'm asking you how they are going to give this year as regards annual income from the accident. So here, it is annual income will be 60,000, 5,000, because he has accepted 5,000. Loss of future earnings of 15% of the prior annual income. Multiplier is 17. Here the same thing applied like Sarlabir Burma. No, that is okay. No, that I have understood. I'm only on the thing. How do you apply the multi?
Same.
Sarlabir. So if it is taken as 15%, here the court did not take into any percentage. So here his annual income would have been 6 lakhs. 60,000. So 60,000 and the disability certificate does not say the percentage of his disability. So how does the tribunal convert it into a functional disability? So the functional disability is taken on a subjective satisfaction of the tribunal. Mr. Goswami, I leave it to you, but tomorrow I take it up at 2. Not tomorrow, on Friday at 2. Or next Monday? Monday? Next Monday? Just find out from the facts and see the records, how much can be given to. And just come up before this court, then I will take it. I'll pass the order. And you also help him
Gotcha.
come up with some figures. The hearing remains inconclusive. List the matter again on Friday, on Monday, date to deliver at 2 p.m. for further hearing of the matter. Mr. Goswami, have a look at this. You have it? You have the records? Yeah. Then this is a scan copy of the records, huh? So you do one thing. This is not the original. Have a look with the scan copy. If you, he also doesn't have.
No, original record is
Both the councils are permitted to have a look at the scan copy of the records. So that it may aid in adjudication of the presence. Have a look at this, how it is required, because these are photocopies. What are you challenging?
Page 71, my lord.
Huh?
Petitioner file an application, my lord, to bring some, my lord, witnesses to adduce evidence, my lord.
Huh?
To bring some 4 witnesses, my lord, to adduce evidence as per, my lord, order 16(1)A, my lord. That has been rejected, my lord. And the said application was filed, my lord, on the completion of the petition, plaintiff witness, as the, my lord, cross-examination of all the witnesses was completed, my lord. Page 71, my lord.
When did you file the petition?
On, my lord, 8/11/2023, my lord.
November.
Yes, my lord.
You are going to file it by yourself.
Yes, my lord.
They will come and give evidence by themselves
Yes, my lord. On every-
and not by way of summons.
No.
Right, Mr.
Yes, sir, Ahmed.
Friends, behalf of Mr. D. Bakshi. D.K. Bakshi, appears on behalf of the respondent. So the supervisory jurisdiction of this court have been invoked to challenge the order dated 23/2024, whereby an application filed under section 151 of the Code of Civil Procedure 1908 for permitting the petitioner, who is the plaintiff in the suit, to adduce further evidence who were of witnesses who were not the listed witnesses was disallowed. This court have duly taken note of that at the time of at the time when the suit was filed, the plaintiff was a minor. It is further seen that the plaintiff had adduced the evidence of some witnesses, and at the time after on the date on which the cross-examination of all the plaintiff witnesses were over, on that very date, an application was filed under section 151 for permitting the petitioner or the plaintiff to adduce further evidence evidence of witnesses who were not the listed witnesses. Although the said petition has been filed under section 151 of the code, but taking into account that there being an express provision which is Order 16 Rule 1A, the said application be construed as an application under Order 16 Rule 1A, capital A of the code. It is further seen from this court had inquired with the learned counsel appearing on behalf of the petitioner as to whether the said witnesses who would be adducing evidence, the names of whom have been given in the application, would be filing the examination in chief by way of affidavit without specifically calling them to adduce evidence by way of summons. The learned counsel submits that the said witnesses, that the petitioner undertakes that the said witnesses would adduce evidence by, would submit the examination in chief on their own without the necessity of calling them, without the necessity of issuance of summons in terms with Order 16 Rule 1 of the code. This code further takes note of that in the said application, it has been duly mentioned that there was some inadvertence on the part of the petitioner, as well as the fault on the part of the advocate, for which the names of these witnesses were not mentioned at the time of furnishing the list of witnesses. It is also relevant to take note of that the petitioner, as on the date on which the said application was filed, was just 19 years. Taking into account the above, this court allows the said application, thereby permitting the witnesses so mentioned in the said application to adduce, to file evidence on affidavit by way of, and file examination in chief by way of an affidavit, by affidavit. It is, however, observed that permission so granted by this court shall not be construed that the learned trial court would have to issue summons in terms with Order 16, Rule 1. The court further takes note of that by an order dated 15/5/2024, the further proceedings of title suit number 03/2021 pending before the court of the learned civil judge senior division Sibsagar was stayed. The said stay order is vacated and the parties herein are directed to appear before the learned trial court, learned court of the so-and-so on 25th of June 2025. It is observed that on the said date, the evidence on the examination in chief of the four witnesses whose names have been mentioned in the application being petition number 1596/2023 dated 8/11/2023 has to be filed. Failure to file the examinations in chief on affidavit of these witnesses on the next date so fixed, would debar the petitioner to file the examination in chief on affidavit of these witnesses in future. Further to that, the petitioner, the learned trial court is further directed to fix the date for adjournment, fix the dates for cross-examination. It is observed that taking into account for cross-examination, it is observed that the shall fix the date for cross-examination and proceed with the disposal of the suit in accordance with
13 and 14.
This CRP has been arising out of same title suit filed by the petitioner.
What are you challenging?
My lord, the petitioner filed a case for injunction along with the plain. My lord, there was an injunction order granted by the munship. Then, my lord, the other side, defendant filed appeal. Appeal before the, my lord, court of civil judge, my lord, and civil judge has.
Why there are two cases?
My lord, there was a injunction petition filed by the defendant also in their counterclaim. Initially, my lord, in my injunction was allowed and their injunction was rejected. And therefore, the defendant filed appeal in both against both the orders, my lord. And in both the orders, my lord, the initial order has been modified and my lord, only status was allowed. My lord.
Now what is the court's direction?
My lord, here in this case, my lord, both these CRP, there in some
Now what
order
is
has
the
been passed
injunction?
saying the
Is there any injunction?
Yes, my lord.
Mr. Chaudhary? And what was his injunction earlier? From entering. Now there is a status quo as regards possession.
Yes, my lord. My lord,
One for what?
my lord, they have, my lord, same, from the same owner, the plaintiff and the defendant, they have purchased land. And they have, by negotiation, they have dug pond, my lord.
Huh?
They have dig out pond, my lord.
Your petition.
My lord, from my side and their side also. In the same land, my lord, they have jointly dug pond. And subsequently, my lord, the respondent, my lord, they are claiming that we have sold out some portion of the pond land and they want to restrain us. They restrain us to enter into the pond.
And therefore, my lord, we have to file the suit, my lord.
for not to restrain you.
Understand?
So
And
that means if they are restraining you, that means you are not in possession.
my lord, my lord, we are enjoying the my lord, pond, both the parties, my lord.
Then
My lord, now they are claiming that they have purchased the pond. Share, that share of that part of the land of the pond that we are possessing, and they are claiming that we have sold out the land, pond land to them, my lord. And therefore they are trying to dispose us. We are not left out the possession, but they are trying to dispose us. Therefore we have filed, and
you
therefore
are
the court
asking-
has granted
so
injunction
you
also,
ask for an injunction not to dispossess
not to dispose us.
by them.
Yes, ma'am.
And they have asked you, what they are asking for.
They are asking for that, uh, that we should leave the possession and they should be in the possession. They are claiming that.
No, that is a different thing, but I am asking, what is the injunction they ask?
Their injunction that they are purchased the pond land, so we should not be there. They should be there, my lord. That is their prayer.
And the court has directed,
Directed, my lord, granted our injunction in our favor because we have a prima facie case because we have the deed.
no.
The-
What does the appellate court do?
Appellate court has said that the plea of adverse possession made by them has not been taken into consideration in passing the order by the trial court. That was the ground taken by the appellate court.
No, that is understood. Now, my question is, what is the trial court judgment?
My lord. In the first CRP, my lord, 326, the trial court judgment, lordship will find at page 70, annexure 6.
They have also challenged, na? Or you have challenged?
My lord,
As it is clear from the facts that OPs there are consent in digging the pond, it will be proper for this appellate court to order and status quo as to preserve and protect the suit pond. Accordingly, it is directed the both parties shall maintain status quo over the suit land till the disposal of the title suit. The order of status quo is binding on both the parties. Then what is wrong?
my lord, we are in possession, and if the status quo is granted, my lord, they will restrain us to enter into the pond.
But they cannot restrain you, but as you are having a status quo. If you are having a status quo, meaning that means as on date, both the sides will remain as it is. If you are enjoying the pond, you enjoy the pond.
On the
If he is enjoying the pond, he will enjoy the pond.
on the strength of the status quo, they will restrain us. They will enjoy the position. That is the problem, my lord.
How?
Yes, my lord. That is our apprehension.
So what order should I pass?
My lord, till the disposal of the title should, both the parties should not be in the possession of the pond. That I will argue.
Both parties should not be.
Should not be in the possession of the pond.
That means you are not in possession.
My lord. Because the pond is a pond joint, my lord.
Then go. Why? Who has filed the suit?
My lord, we filed the suit because
Go.
they are,
You go before that court. Those executive magistrates get a year for
my lord,
attachment.
that is,
Attachment, not to be, as regards dispute may arise, so attachment, go there. They will pass these type of orders. Where is this? Baksa.
Baksha, my lord.
Then go there. Those are the persons who can pass that order. I don't have that jurisdiction. Order of the first appellate court seems to be right. If you are not in possession, how can you? Therefore, my question
Well,
is,
we are in possession.
so if you are
We
in
are
possession,
claiming that
means-
we sold.
you want a clarity? I can say the possession as both the courts, as the appellate court categorically directs both the parties to enjoy to maintain the status quo and preserve and protect the zone, the parties shall maintain the possession status quo as regards possession title over the suit pawn till the disposal of the appeal.
My lord, my
That means you are not in
party
possession.
is humble and simple. Other side is very, my lord, desperate. My lord, they are throwing out on the.
Now, how do I know that you are in possession? How do I know that you are in possession?
My lord, that will, my lord, can be read out from this case, my lord.
They are claiming adverse possession
They are claiming adverse possession
over
over the pond land.
from whom?
My lord, that
Adverse
is the,
possession
that is the
against
question,
whom?
my lord.
Huh?
We jointly, my lord, from the same owner, we sold out a portion, they have sold out a portion.
Understood. They have purchased, you have purchased.
My lord.
Adverse possession against whom?
Well, they are claiming from us, my lord,
From
because
you.
they claim that we sold out the pond land. Therefore, they are claiming adverse possession. That is not correct. And they are claiming that we sold on Bharveli, no deed of sale.
No, no, have you sold or not?
No, actually, it's totally false, my lord.
You have not sold.
Not sold.
You only said that you have sold.
No. They are claiming. They are claiming that we have sold without any deed.
So you are in possession.
We are in possession.
Remain in possession. Status quo is given. He also says that he is in possession. Let him be also in possession. The best
Therefore,
option
my-
should have been.
Therefore, my
the
the
co-
quarrel will.
No,
be
no,
there.
best option should be that you should file an application under order 37 rule 6, 39 rule 7 before the learned trial court, asking for making an inspection who is in possession and thereupon pass an order. If you want specific. Otherwise, this is order seems to be right.
I leave it, Lordship, my lord.
You don't leave it
That-
to me. Mr. D. Chaudhary. After asking him few questions, he has left it to me. Now tell me. Both of you. By them. Hmm. Hmm. Then? So where is the question of adverse possession?
My lord,
They are still accepting.
the plea of selling the pond land is totally false and baseless. So, my
Whatever
lord-
may be, it's a verbal, they are saying.
my lord,
So
can be, my
verbal,
lord,
so
sold,
verbal, that means are they not admitting you as the owner?
I am the owner, my lord.
Very well.
Hmm.
Then, next. So now what is their suit for? Let us see the plaint.
My lord, that
Issue a
is
decree
annexure
declaring
one.
the plaintiff's right, title and interest, issue a decree restoring the khas possession of the plaintiff upon core land, meaning thereby you are not in possession.
My lord, restoring first position means we are in position. They want to disturb us, therefore we want
For
to.
restoring khas possession means you want the possession back. Recovery of possession.
My lord, the trial court has, my lord, discussed, my lord, everything, and trial court hold that we are in possession. And they have no prima facie case.
Restraining to cause unauthorized entry into the core land during the pendency of the suit. My goodness, this is more of a mandatory injunction. Pray for recovery of khas possession is made in the event of dispossession by the defendant during the suit proceeding. Huh? Bond. I think so. Chalo. What to do? We direct the, okay, appealate order seems to be good. Directing which make it clear that the status quo order shall be remain as regards possession. As regards possession. You are saying you in possession. And giving liberty to both the parties to file appropriate application before the learned trial
Right.
court for inspection
Right.
and for issuance of commissioner and whatever.
Right.
Heard Mr. A.R. Sikdar, the learned counsel appearing on behalf of the petitioner in both the applications filed under Article 227 of the Constitution, as well as Mr. D. Chaudhary, who appears on behalf of the respondent or respondents. Respondents,
My lord, respondent,
respondents.
three respondents.
Respondents in both the proceedings, in both the revision proceeding, in both the applications. First, the petitioners herein have assailed the order dated 26/7/2024, passed in Miss Appeal number 1/2023 in CRP IO number 410/2024, as well as the order dated 26/7/2024, passed in Miss Appeal number 2/2023 in CRP IO 326/2024. Taking into account that both the proceedings arise out of the same suit, being title suit number 14/2022, by the present order, this court proposes to dispose of both the proceedings, both the applications. Full stop. From the records, it is seen that the petitioner herein, as plaintiff had instituted, petitioner in both the proceedings as plaintiff had filed a suit being title suit number 14/2022, seeking a decree for declaration of right title, interest, as well as recovery of khas possession and for permanent recovery of khas possession and for permanent injunction. The petitioner also seeks for partition of the suit property as described in Schedule Q. The case of the plaintiff, the petitioner in the suit is that the core property described, the property described in Schedule Q was purchased by the plaintiff from the original Pattada 1 Sri Harish Chandra Medhi by executing a registered sale deed number 41 and had been enjoying the same till the date of filing of the suit by constructing a residential house thereon. Full stop. It is further mentioned that the Schedule Core, the land mentioned in Schedule Core, is covered by DAG number 476 of old Patta number 2 and new Patta number 339 and DAG number 820, and the total area is 2 Katha 10 lechas, which is the suit land. And Schedule Core is a part of the Schedule Core land. It is further mentioned that the defendants had purchased equal portion of land on the same day, along with the plaintiff from the same DAG and Patta numbers. And in that regard, a description, the diagram had been mentioned in the plaint itself. In the said Schedule Core land, which is the suit land, both the plaintiff and the defendants are possessing, and they have dug up a common fishery for rearing fish. Full stop. It is the case of the plaintiff that the defendants were trying to encroach the land of the plaintiff described in Schedule Core, including his fishery and Bitalnath garden on the western side. Full stop. As the plaintiff had opposed the said illegal attempt of the defendants, the defendants filed an application before the Circle Officer of Tamalpur Revenue Circle, praying for demarcation of the boundary. And the officials, that is the local Nath Mandal, along with the three Mandals, came to the spot for demarcation and warned both the parties from making any, not to quarrel and not to conduct fishery in the pond, fishing in the pond. It is the further case of the plaintiff that the defendants, in spite of that, was taking steps for, was unauthorizedly entering into the fishery and trying to occupy the land of the plaintiff described in the Schedule Core by breaking the fencing and openly threatening the plaintiff by the defendant. And it is under such circumstances the suit was filed, seeking declaration of right title and interest of the plaintiff over the suit land described in Schedule Core, as well as for recovery of khas possession, as well as recovery of as well as a decree for restoring the khas possession of the plaintiff upon the scheduled call land, etc. Along with the said suit, an injunction application was filed, and the learned trial court, by an order dated injunction application was filed, which was registered and numbered as Ms. case number 10/2022. And the learned trial court, by an order dated 1/6/2023, directed the opposite parties, that is the respondents herein, not to enter the suit land or disturb the peaceful possession of the petitioner until the final disposal of the connected title suit or until any further order. It is relevant to take note of that the defendants, the respondents herein who were the defendants, also filed a counterclaim claiming right over the suit land on the basis of adverse possession. Along with the said counterclaim, an injunction application was filed, which was registered and numbered as different. He filed another
Appeal-
injunction, na?
Appellate order, Your Lordship will find at page
No.
76.
Injunction order he has filed.
Yes, that I have, I
Now,
have
Mr.
annexed only
Chaudhary?
their appellate order.
Mr. Chaudhary, did you file an injunction application? His case is one. to one হয়, huh? Miss case one. হল এখন file করলে। Also filed an injunction application. Seeking a temporary injunction restraining the petitioner's hearing. Who filed this? There were two applications filed by him.
My lord, no. Their application number means number 1/23.
They filed.
Yes, sir. That annex my lord, in the
এখন
CRP
10/2022
410.
আর এখন হল কি হয়? Where is that other one?
While other one, Lordship will find in CRP 410 at page 91. They are Mitchell. 91 annex 9.
Had filed an application. Gusto. Had filed the defendants, more particularly the defendants, the respondents herein, and more particularly the defendant, the respondents herein filed their written, the defendant number 2 to the said suit filed the written statement along with the counterclaim. Gusto. Claiming right over the entire suit land on the basis of adverse possession. Along with the said counterclaim, the defendant number 2 also filed an injunction application, which was registered and numbered as Ms. Z case number 1/2023. Seeking a direction upon the plaintiff, his men and agents from entering into the suit land of the counterclaimant till the disposal of the suit. Full stop. The said application being Miss J case number 1/2023 was dismissed by an order dated 1/16/2023 on the ground that the counterclaimant did not have, on the ground that the defendant number 2 did not have any right full stop. Resultantly, 2 appeals were filed by the defendants who filed the appeals.
My lord, dependent.
Both.
Dependent number two. Yes,
Oh, defendant number 2.
Yes.
2 appeals were filed by the defendant number 2, who is the respondent number.
my lord, the petitioner present.
Respondent
petitioner-
number 1 herein,
Present petitioner, my lord.
which were registered as Miss Appeal number 1/2023, isn't it?
Yes, my lord.
1/2023, as well as Miss Appeal number 2/2023. Full stop. It is very relevant to take note of that Miss Appeal number 1/2023 is directed against the order dated 1/6/2023 passed by the learned court of the Civil Judge Junior Division Buxa, whereby Ms. J case number 1/2023 filed by the defendant number 2 oblique the respondent number 1 herein was rejected. And Ms. Appeal number 2/2023 was filed against the granting of an injunction by the learned court of the Civil Judge Junior Division Buxa in Ms. J case number 10/2022, dated 1/6/2023. It is seen that both the courts, it is seen that the learned court of the Civil Judge Senior Division Buxa allowed the appeal being Miss Appeal number 1/2023, thereby directing both the parties to maintain status quo over the suit land till disposal of the title suit. Similarly, Miss Appeal number 2/2023 was also allowed, passing similar direction that both the parties shall maintain status quo till the disposal of the suit land. It is under such circumstances both the applications are before this court. This court had heard the learned counsels appearing on behalf of the petitioner, as well as the learned counsel who appears on behalf of the respondents, more particular respondents. This court had inquired with the learned counsels appearing on behalf of the petitioner as to whether the petitioner is in possession of the part of the it's a part of the is in possession of the suit land. He submits that the petitioner still is in possession of the suit land, but intermittently the defendants continue to disturb. Per contra, Mr. D. Chaudhary, the learned counsel, submits that in the year 2001, the defendant, the plaintiff, had sold the suit land to the defendant number 2. Defendant number 2. verbally. Defend number one, no, respond number one. Respond number one to that Punya Bormon, no. Is the defend number two, but here is the respond number one. To the respondent number one herein verbally. And thereupon, after various requests, as the deed of sale was not executed, the respondent number one have been enjoying the entire suit land, openly expressed, openly hostilely, and adverse to the rights of the plaintiff, oblique petitioner. He therefore submits that the plaintiff petitioner is not in possession of the suit land, of the suit land. Full stop. This court further finds it relevant to take note of that neither the learned trial court nor the learned first appellate court had taken into consideration, while passing the impugned order, as to who is in possession of the suit land. Be that as it may, it being a settled principle of law that at the time of filing of the suit, the status quo is required to be preserved. It is also the opinion of this court that the learned first appellate court was justified in observing, while disposing of both the appeals, that the status quo over the suit land till the disposal of the suit is required to be preserved. Full stop. Under such circumstances, this court is also of the opinion that the learned first appellate court was justified in passing an order of injunction in favor, thereby directing both the parties to maintain status quo up in respect to the suit land. This court, however, would like to add that the status quo so directed by the learned first appellate court shall mean the status quo as regards the possession over the suit land till the disposal of the suit. This court further taking into account that both the parties are claiming that they are in respective possession of the suit land, would be at liberty to file appropriate application before the learned trial court for appointment of a commissioner if so advised, to ascertain as to who is in possession. Deep lovely. Do you have a good thing? They will file application. Yes, what is this? Oh, Guardianship Act.
Lordship, your lordship have passed an order on 2/5, your lordship. Your lordship, hereafter, your lordship, I have produced that.
Oh,
order.
yes. What has happened?
Your lordship, I produced that order before the family court, your lordship. I got the certified copy of the order yesterday only, so I couldn't file an affidavit. I can produce those orders later.
What does it, what is it? Has the hearing been expedited?
Your lordship, nothing as such happened, your lordship.
What?
Yes, your lordship. That's the claim, your lordship. And your lordship, since 29/7/24, your
At the
lordship.
time of writing the
The
order,
opposite-
the OP is present with the minor child, the OP is directed to play with the minor. So you met the child.
Yes, your lordship, because in the earlier order, your lordship,
Order for ex parte is recalled, fixed so and so for production of the child. So it is fixed on 36 for production of the child.
yes, your lordship.
Oh.
Your lordship, but till now, no order has been passed, your lordship, regarding the my interim prayer and your lordship.
They will pass, wait. Everything will happen, wait. Things will, you met on the, after how many years you met? 3 years?
2 years.
2 years. Now on 36, you again meet?
So, and your lordship, another thing is that your lordship, since 29/7, your lordship, the learned family court has been reflecting in its order, asking the opposite party to file written statement as last chance. Every time your lordship comes and file an application for recalling that order, and the learned family court recalls the order. Again, this time also he recalled the order.
So I am praying for an order, Your Lordship, that if written statement is not filed on 36, Your Lordship, the proceeding may proceed, Your Lordship, ex parte, Your Lordship, because 1.5 years, Your Lordship.
Mr. Counsel, don't look proper.
1.5 years, Your
Dekho.
Lordship. Since the
Mr. I. Hussain, the learned counsel appearing on behalf of the petitioner, has drawn the attention of this court that pursuant to the order dated 2/5/2025 passed by this court, the petitioner could meet the child after more than 2.5 years on 27/5/2025. He submits that the next date is fixed on 36/2025 for written statement last chance and for production of the child. Full stop. Taking into account the above, this court fixes this matter again on 16/7/2025. Full stop. This court hopes and expects that the learned court, full stop. Yeah. It has been submitted by the learned counsel appearing on behalf of the petitioner that since the month of July 2024, na?
this order for written statement,
Huh?
September 24.
Since
Your Lordship, 27/9/24.
27/9/2024, the respondents have been given the opportunity to file their written statement, comma, and as such, appropriate directions be issued by this court. And until date, the respondent have not filed their written statement, and thereby delaying the said proceedings.
Lordship, may I interrupt? Your Lordship, actually, the opposite party was asked to file written statement on 21/3/24. It was on 29/7, Your Lordship. She was asked to file written statement, and it was last chance was accorded to on 29/7.
Submitted that on 29/3/20,
9/7.
29/7/2023-24. The respondent was given a last chance to file the written statement, but till date, no written statement has been filed, and this the learned court had also given another further chance on 36/2025 as a last chance. He therefore submits that in that process, the respondent herein is delaying the disposal of Ms. G case number 163/2023. This court would not at this stage pass any orders in that regard, taking into account that the principal judge, Family Court number 1, Kamrup Metro, is duly dealing with the said aspect. Taking into account the interest of the child, interest and the welfare of the child, this court opines that the learned principal judge, Family Court number 1, Kamrup, shall make an endeavor that the said proceedings could be culminated at the earliest. List the matter again on the date above fixed for an update. This last line will help you a lot.
16.
What? You are on caveat? You are on caveat? Then it has come for the first time. For appeal.
Matrimonial appeal, Lordships.
Ah.
Lordships, I am the wife, Lordships.
Ah.
This respondent is husband.
Ah.
Respondent filed a divorce petition, Lordships,
Ah.
and this
I allow dissolution of the marriage between the parties with effect from the date of the decree. Okay, then
Lordships, this I have not received the summon, lordships.
Uh,
And without receiving any summon,
Uh.
this order was passed. Order was passed on 4/3/24, lordships.
delay condoned.
Delay condone, lordships.
Okay. Then
Lordships, now page 20, lordships, that is the order of divorce, lordships.
Hmm.
Lordships,
ex parte.
ex parte, lordships.
Then?
I have not received the summon, lordships.
Okay.
And when this appellate.
Why didn't you file an order 9 rule 13?
Lordships, when this,
You know, Mr. Sharma, what is the effect? I will only touch on the merits when you are in appeal. So therefore, I cannot go on the summons business much. But the summons business can be gone there. If you have anything on merits, problem is you don't have evidence. See that is a big problem do you face. I can admit it. This will go on. Then
now, lordship, my humble prayer, as ex parte order is passed, I have not been served with the summon, lordships. I could come to know through the learned counsel from the respondent, lordships. So, lordship, then immediately, lordships, I rushed to the honorable court, applied for the certificate copy of the entire records. After getting all the records, lordship, then I have preferred this appeal, lordship. Lordship,
where is the record?
Lordship, this page number 18, lordships. That is the order, lordships, 13/6/23. 25/7/23, ex parte order passed, lordships.
Where is the next order after 24/1?
Lordship. 24/1, lordship. That order is not with me, lordship. Then this is the order, lordship. Final order, page 20, lordships.
So
Order,
you don't want to give divorce.
I don't want to give.
Who is
that.
appearing? You? Only on postal track consignment, postal receipt and the download you have suggests that notice have been served on demand. She has not turned up, so and so.
And sent me advocate notice and that maybe typing
During this
mistake
period, he took the opportunity and sent me advocate's notice.
and case of a copy of for divorce. That means the copy of the case for divorce.
Uh,
This is admitted by the appellant that he received the copies, both the copies, advocate notice as well as divorce petition. And now the plea is that she has not received the copy. Now plea has been taken that she has not received.
But this was only on 28/6.
That is FIR has been filed on that day.
Okay,
the
but then also,
copy of the case.
this happened when? Sir, my marriage solemnized as per Hindu. After marriage, my 100,000, my parents here to fulfill her new demand. I came to my parental and I have been seriously injured. Till now, my treatment is going on. During this period, he took the opportunity and sent me advocate's notice. When was the advocate's notice?
My lord, just prior to the filing of the case, my lord, that is, my lord, I am doing.
Huh?
My lord, on
And what is the can of copy?
9/6/2022,
Case
my lord.
of
Read us.
copy of divorce.
Yes, my lord.
On phone, he gave me threatened that if I will go to so and so,
Yes, my lord.
I will therefore request you to kindly look into the matter. Then,
My
what
lord,
is the birth certificate for? You've got a child.
Yes,
On child is there, it is with me, lordship.
my lord, the pleaders notice was sent on
Huh?
9/6/2022, my lord.
Ah,
The pleaders notice was sent.
then,
My lord, that is received, my lord, and after sending the pleaders notice, the case has been filed, my lord. That divorce petition has been filed. After serving the pleaders notice to the appellant, my lord,
that is a different thing, but
Yeah.
whether the service was properly done is the question.
that is admitted in the FIR, my lord.
FIR was filed in after the decree was passed.
My
Lordships.
lordship, that may be,
Lordship,
my lord,
that is
but,
the fact, lordships.
but
This decree obtained,
I-
then
I
this,
have-
then this communication was made through the learned council.
So,
That's
so,
made
so
by
you
the-
have married again.
yes, my lord. After
Okay.
decree of the my lord.
So we will do one thing. What is this IA for?
IA for condonation of delay.
No, this IA
This I for maintenance.
pay rupees 25,000 per
Yes.
month. We issue notice on this. There's no stay
Lordships.
because he has already married.
Yes.
So there's no stay. I make it clear also. Because I think. Okay, issue.
Further, my lord, I'll take
Heard
it.
Mr. So-and-so, the learned counsel appearing on behalf of the petitioner and Mr. So-and-so who appears on behalf of the respondent.
Yes.
Gustav, this is an appeal file under section 20. What is that? Section 28 of the Hindu Marriage Act 1955. Why 28 you are doing it? 28 of the Hindu Marriage Act 1955, challenging the judgment and decree dated 24/4/3/2024, whereby the learned court of the additional district judge Gwalpara had decreed the divorce proceedings ex parte against the appellant herein. Gustav, taking into account the grounds of objection, the appeal is admitted, call for the record, steps be taken by way, also taking into account that the respondent is duly admitted and duly represented, extra copy of the memo of appeal be served upon him within 2 days. Gustav. It is also brought to the attention of this courts that in the meantime, prior to the filing of the appeal, after the decree of divorce, the respondent have already remarried. Is it or not?
Yes, yes.
Do you admit or not?
Yes, my lord. Yes, my lord.
Okay, remarried. Good stuff. The said aspect is being duly taken note of in the present order, taken duly note of. I issue notice, Mr. So-and-so accepts notice. He submits that he would file an objection to the said application. List the matter again on after vacation, 16th of July. Issue notice.
17.
On 16. You file your objection by then. Yes, MSc, madam, tell me.
Appeal against Quantum Miller. Appeal against Quantum Miller.
How much?
17 lakh
Why? Ground?
ground, income is on the, assessment of income is on the
Huh?
higher, assessment of income is on the higher side. Because, he was a rickshaw puller and monthly income was taken is, 8,000.
As per this, na? Notification.
He was not under rickshaw puller. He was not rickshaw puller. He was a employee of private firm.
Where is it rickshaw puller?
His father is rickshaw puller.
Father is rickshaw puller.
And
So-
moreover, another ground is that deceased was, aged 40 years.
Huh?
Deceased was aged 40 years. 40% of the future prospect was taken, should be 25% Miller.
40 years then
40 years, then future.
was
prospect
below 40 years, as the deceased was aged 40 years
below
and was
40 years.
self-employed, 40% of the years should there be. should be added. Because the honorable had held that while determining the income for self-employed or fixed salary, 40% of the amount should be added towards if the deceased was below 40 years.
That was just
But as he was 40 years,
the future prospects to be taken as per Pranesh Shetty judgment.
you want 25%. Calculate 25%, we dispose it off. And nothing more. Yeah, he has see. And
The monthly income was on the.
income is okay, rightly done. No more. Matter ends. Take this. By 4:30 inform me. We dispose of. So, repeat it.
18. Yes, it doesn't look like it is a road traffic accident. What had happened, Lordship, the postmortem report says asphyxia due to, Lordship, as a result of antemortem drowning.
Antemortem.
And Lordship, everywhere, stomach, thorax, everywhere, it was all filled with sand and mud.
Huh?
Sand and mud.
Oh.
The insurance company had even called a doctor who had conducted a postmortem. He had deposed before his evidence was rejected because he did not bring the register. Lordship. When the postmortem report filed by the claimant was there, he was deposing on that. That ought not to have been rejected so mechanical, Lordship. That ought not to have been rejected by the learned member so mechanically. Lordship, I'll take your Lordship. Larynx and trachea were congested and contained sand and mud. Similarly, stomach also contains mud and sand particles. This observation means that the person was alive when he was drowning. Only then it would have gone inside. For a dead man, this will not go inside. He was first hit by some blunt object, then he fell into water. It was so, it has been projected as a case of motorcycle knocking down the. This is Lordship, the accident occurred on the bridge, Lordship. No, the accident occurred on the bridge, Lordship.
Beach.
Bridge.
Where?
Road bridge. And the person fell down in the water, Lordship.
Is it?
Yes, Lordship. And charge sheet is also there, Lordship. Police has investigated the matter. And they have examined the doctor, Lordship. But who has conducted the PM postmortem report? He was not examined, Lordship. He wasn't. And based on the doctor DW1 and they've.
Postmortem report, who gave?
Claimants.
Who? It is your document.
Yes, Lord.
Then,
They have.
so you had, the moment you give that document, you are admitting to the contents.
Postmortem were to give, Lordship, because the.
No, so therefore, you are admitting to the contents of the postmortem.
Contents.
Why do you need again? They have to prove that document when it is your document.
So, Lordship, they have called the doctor to prove the postmortem, Lordship. And doctor has said that
No.
before death.
Then appeal filed on the so and so, so and so, so and so. The ground of objection taken is that the accident, the ground of objection taken is that the learned tribunal failed to, had misconstrued the evidence on record and had arrived at a finding that it was a motor accident, it was a motor accident, no?
Yes, Lordship. Yes,
It was a motor accident, rather it appears from the evidence on record that it is a case of drowning, for which the question of availing remedies before the motor accidents claims tribunal does not arise, without taking into account the grounds of objection, comma, the appeal is admitted, call for a record, steps be taken. We don't require the owner. Do you require the owner?
Lordship, he will be required.
Why?
Lordship,
Because
I
he
would
is
take
the
note
co-
of
is
your
the party
examiner.
who is in collision with the claimant, Lordship.
Huh?
If the motorcycle is not involved, he is colliding with the claimant in that case. They are in collision, Lordship.
But if your ground is the objection is only on that, then
But
then-
they try-
Then what does owner and rider have anything to do with that? Does he have anything? I can, but the only problem is why should I delay it? Because I'm not going to stay. I'm going to stay the 100%. So therefore, I'll go for an early disposal. Once the record comes, we'll dispose it off.
Yes, Lord.
No, 5 and 6 not required.
Not-
He appears for the claimants. You appear for 1 to 4.
Yes, Lord.
Mr. Yeah, 1 to 4 appear Mr. A.R. Agarwal. Now for the respondent number 4, who is on caveat, whose extra copies of the memo of appeal be served upon him within 3 days. So as regards the respondent number 5 and 6, taking into account the ground of objection so taken, comma, the question of, and did they file their affidavit, written statement?
Lordship, the owner and I, so I'll just see.
Filed.
Lordship, this is a charge sheeted case, Lordship.
Huh?
This is charge sheeted case, Lordship.
Understood. We'll do it.
Reason what is nowhere mentioned in the judgment.
Because you are not saying that he is liable. Your basic case is a case of drowning. So the moment he is not a case of drowning, then the owner doesn't have no business. So taking into account the ground of objection so taken, the name of the respondent number 5 and 6 is struck off from the records. Struck off, comma, the appellant, the counsel for the appellant is directed to file a fresh memo of parties before the registry of this court. And the registry on the basis of the same within 7 days shall file me. I continue. This is an issue notice making it returnable on 5th of August 2025. Steps be taken by way of is an application for stay of heard Mr. So-and-so, and Mr. So-and-so appears on behalf of the respondent number 1 to 4, comma. The name of the respondent number 5 and 6 is duly struck off, comma. This is an application filed under Order 41, Rule 5 for stay of the judgment and decree, comma, taking into account the ground of objections which have been taken, comma. This court stays the entire judgment and decree, judgment and award dated so-and-so till the next date. Full stop. This court further observed that an attempt shall be made to dispose of the accompanying appeal, comma, if in the circumstance the appeal cannot be disposed of on the next date, comma, this court shall pass appropriate orders on the stay application.
All right.
Yes. Give it a chance.
This appeal is prepared by the owner of the vehicle, Lordship, that 1 year child, Lordship, it is stated that he was standing on the road, Lordship. And he was, due to rash and negligent driving, he was sustained injuries. But the main fact is, Lordship, that my tractor was taken by the hire by the claimant's, Lordship. It was standing on their.
You are the owner,
Yes, Lordship.
owner of the tractor. Then why you are challenging? You didn't
Lordship,
have
the
an
thing is,
insurance.
164, before amendment, case of before amendment, Lordship,
Hmm.
without notification.
Hmm.
So 164, it is filed, Lordship. After amendment in 2000, after 24, Lordship, it is filed, Lordship.
This is a direction for you to pay 5 lakhs.
Yes, Lordship.
You paid. Why?
But the thing is, this, Lordship, it is 2021 case, Lordship. At the time, this section was not there, Lordship. That was 140, Lordship, for NFL. 164 was not there, Lordship. It was not
For?
notified. 164 MB Act, Lordship, it was not there.
Then
Then award was, case was filed in 164. So there is a, that should not be maintainable, Lordship. Because at the time, 140 was there, Lordship. And it was a common notification in 22, Lordship. 1422, Lordship.
And accident was of 20221 Lordship. And Lordship, 1 year child, how he can, or she can stand on the road, Lordship? He cannot even stand up. It is mentioned that the deceased was standing on the road, Lordship. So there is my objection, Lordship. So that will make admitted and
50%.
no, Lordship, the thing is.
50%. 50% you have to pay because in other cases, then you promise that you would not insist on a 50%. Other side, you say, give me an undertaking that next onwards, all appeals,
Yes, Lordship.
when you are for the other side, you would not insist for a single penny. No, okay, we don't give you. No, tell me. A child has been lost. 5 lakhs is too much. That day, a 5 lakh amount has been given. Do you remember in that day,
Yes, sir,
that
but-
case,
yes,
the
sir.
3 lakhs entire amount was directed to be delivered and the 5 lakhs has been deposited. So, along with the interest you deposit, the entire amount will see 50% be released and 50% will be kept.
There is a non-joint and misjoined party also, Lordship. The court has not. observed
Mr.
that.
Agarwal, I am not going to look into all these things in a claim proceedings.
Lordship, we have
Non-joinder and
also paid
misjoinder.
some
Where's your
amount.
written statement? Where's your written statement? Show me. Did you raise that issue?
Yes, Lordship.
Non-joinder or misjoinder?
Yes, Lord.
Where is it? Where?
Chairman board. And claim was 25 lakhs, Lordship.
Hmm.
164 limited amount is 5 lakhs only.
So they got 5 lakhs.
Yes, but the claim was, they have proved rash and negligence. But my tractor was standing, Lordship, in front of their house, private place. And the mother of the.
And what, there's a charge sheet?
Yes, Lordship, there is a charge sheet.
There's no charge sheet.
Yes,
Are you sure?
yes, Lordship. And they threatened us and.
You say there is no charge sheet. Don't you read it? Exhibit 2 is the charge sheet.
Yes, Lordship.
Then there it has been said we ration negligent driving. Just now, in earlier matter, you said the one that, na, charge sheet.
Yes, Lordship.
Then,
But Lordship has not paid me. Lordship is state and I have not paid me.
Ah.
That is my nearby village, Lordship, and we paid some amount to them also.
Mr. Agarwal, the entire Northeast is nearby for you. Taking into account, you know all the
Lord,
language of all the people, which nobody else in the under High Court will know. You write from all language, from Khasi, Boro, Missing, all these languages you know.
My pleasure.
You can talk to every person
My
whoever
pleasure,
it is
Lordship.
there.
My pleasure, Lordship.
Then, okay, deposit the 5 lakhs along with cost. Along with interest deposit,
No, Lordship, the thing is this,
50%. 50%?
Lordship, 1 lakh will be.
No.
Okay, Lordship.
Feel admitted. All for area.
Stay of the,
Stay subject to deposit of 50% along with interest.
stay. Because
Along the claimant should be entitled to apply appeal before registry and the registry shall upon verification release the amount.
But Lordship, the case may be put up in the next Lok Adalat, so
What?
we can- Next Lok Adalat, so we can dispose of.
No, the next step, Lokadal is for the remaining 50. Which one? I deposit, dispose. Yeah, you are okay with the rate? Okay, we dispose it of. Finish. Most motions, they did not come, so we'll pick up the motions at 4:45.
Item 20,
Yes, Mr. Sekia.
Lordship, in this case, the insured vehicle was a four-wheeler, Lordship, a Maruti Dzire four-wheeler vehicle, Lordship. But driver had license to drive only two-wheeler, Lordship, only motorcycle. So there is breach of policy condition, Lordship. A driver did not have license to drive LMP, Lordship. Only motorcycle he had license.
Hello.
So there is. breach of
Otherwise,
policy.
there is no other ground?
Other ground also, dear Lordship.
What other
So
one?
2 lakhs rupees given for pain and suffering, but the victim had died in the meantime, Lordship.
Huh?
During pendency of the case, this is an injury case, Lordship. So during pendency of the case, he expired, Lordship. So
So
that,
should we enhance it?
Lordship, that.
No,
2
we
lakh-
enhance it then.
No, Lordship.
No, we enhance it.
No, Lordship.
Why?
Because it is a injury case and it was treated as injury case, Lordship.
Now, once he has died
Yes, Lordship.
because of the injury.
No, Lordship. There is no material to prove that no postmortem report is there, no, Lordship, medical evidence is there. So it was treated
When
as
did
a-
the deceased die?
after 3 years, Lordship, in a 2022,
Ah.
an accident of 2019.
How did he die?
Natural death, Lordship. There is no material to prove that he expired due to accidental
Hello.
injury, Lordship.
Okay, stay subject to deposit of 8,36,565.80. Ground hold that ground of objection that the person concerned. The two grounds of objection. First ground is that the person, the driver of the vehicle did not have did not have the license for driving the vehicle because the offending for driving the offending vehicle, and as such there was a violation of the terms of the conditions of the contract. Secondly, the learned tribunal failed to take into account that the compensation on account of pain, shock, and sufferings could not have been granted, taking into account that the deceased had already the injured had already expired during the pendency of the
MSC case, dear Lordship.
the claim proceedings, isn't it?
Yes, Lordship.
On these grounds, appeal admitted, stay subject to deposit of rupees 8,36,565.80 along with interest
Lordship,
at the
interest
rate,
also, we have challenged,
the rate
Lordship,
of-
9% in the higher side. Lordship.
at the rate of 9% is okay.
Lordship, that is our challenge.
Every case 9% is given along with the 9%.
Maybe.
Because anyways, this is less, I'm giving 2 lakhs
Yes,
less.
Lordship, but interest is also under challenge, Lordship. So at least it's just, Lordship, 6%.
Till it is not finished, it is 9% along with 9%. It will deposit cover, that he line to look at him. If in the circumstance, the appellant is successful in the area, this court shall pass appropriate directions for recovery of the said amount from the owner. And I do release it. Claimant can release it. Now, who is the claimant here?
Claimant is, Lordship, wife.
You have made the wife.
Yes, because it procedurally defect, that person who was expired, his name is also found in the judgment. His name was not deleted. This is the judgment. A dead person was party in this case.
No, but you have made the claimant. You have made the wife party
Wife
here.
is claimant, she was already in one of the claimants. Lordship.
I disposed.
Twenty-one.
Ground?
Lordship, victim was the government servant, Lordship, he died in harness.
সেইটো মোৰ যে এইটো order আছে এই in harness সেইটো দি conventional heads along with interest সেইটো pay কৰি দিব আৰু stay is subject to deposit of that conventional heads. How much is the conventional head given?
2,78,300.
Plus along with the interest. What is the interest given?
9%.
9%. Along with the interest, we deposited within 6 weeks. And next date to deliver on 16/7.
Much.
Call for the record. 16/7. এই কেসটা রিপেয়ার করতে এই বিয়ানি পুরো কেস I notice.
22.
Oh, another one.
Like, this is for enhancement compensation, Lordship. Only the ground is that income was taken 7,500, Lordship.
How much it
He
should
was
be?
a skilled, the electrician, Lordship.
Huh?
And exhibit 18, 19, 20 are the skill certificate, Lordship.
So it should be skilled. The
I feel like
ground
I
of-
need-
the ground of objection taken that the monthly notional incomes were taken was on the lower side, taking into account that the appellant, the deceased, not deceased,
Yes, Lordship.
deceased,
Yes,
the deceased,
electrician
the
skilled
deceased
labor. And
was a skilled workman as he was an electrician. And as
efficiency
such-
certificate is also given, Lordship. Efficiency certificate also exhibited,
Was an
Lordship.
electrician. The learning council therefore submitted that the compensations were awarded was not just and fair, just and reasonable compensation. And as such have sought for enhancement from taking into account the ground of objection, the appeal is admitted, call for a record steps.
23. Lordship, here also the deceased was a contractor, Lordship.
Conductor,
Yes, Lordship. So contractor, government contractor.
and how much it is being given?
And his ITR is also given. So income is taken 11,500 only, Lordship.
And how much was shown in the ITR?
ITR it was 20,000, Lordship.
Huh?
20,000, Lordship.
Where?
Only 3 years ITR has been given
Uh,
and only 1 year has been taken into account.
was earning monthly income of Iman annually. He had exhibited income tax reports and so and so and so the income had submitted Iman available from the Iman tender Iman. According to him, the annual income there was verified that can be in 19.
GST certificate also and given and the sanction letter of this work order also given, Lordship.
So he has come to rightly 1,39,000 on the basis of exhibit 18.
No, that exhibit 17, 18 and 19. There are 3 exhibits, Lordship.
So
Three ITRs.
19 is at the time when he died, after he died.
Yes, but 17 is also there, Lordship.
You filed it subsequently after he died.
No, Lordship, ITR, it is to be kept for 3 years, Lordship, pending.
Huh?
ITR can be filed after death also.
So that is why you filed it at the death.
No, Lordship, because the person die, how can I stop the death, Lordship? Because at the time of his work,
So therefore you filed it after the death.
no, that,
Huh?
that is when it will be due, Lordship, I will go to file.
Okay.
And earlier one is.
The ground of objection taken is that the income so
Not taken into account, Lordship.
the while arriving at the monthly notional income, the learned trial court, the tribunal failed to take into account the evidence on record, more particularly exhibits 17 and 19, wherein the income of the income tax returns of the appellant of the deceased was much higher.
Taking on the stress, Lordship,
Huh?
the main concrete point, Lordship, is stressing on the concrete point, Lordship. Thank you, Lordship. Much welcome.
Twenty-four.
In this case, Lordship, the claimant, Lordship, is hit by-
Ground.
grounds is, Lordship, that the claimant was hit by an unknown truck, Lordship. And the truck fled away, Lordship. The claimant has made the part of the insurance of the motorcycle, Lordship, and this award was passed. No FIR, Lordship, only on the basis of GDMC, Lordship.
Oriental Future Insurance. What is that? Name? Who is the person who writes so badly? तो देखिए बुझिए ना बैठ. What is the name of your Oriental company?
Oriental Insurance.
How much it has been given? 8 lakhs.
Yes.
What is your ground?
Grounds is that, Lordship, they sustain injury themselves, Lordship. That one truck, unknown truck hit the bike of this claimant. And the truck fled away, Lordship, after causing the accident. They have, Lordship, made a part of the bike, insurance of the bike, and trial court has awarded against the bike, Lordship. Not the truck. Truck would not be, Lordship, trace out.
So who gave the evidence?
It was, Lordship, by our insurance has also given, Lordship, and claimant himself has admitted in his deposition that yes, they were hit by an unknown truck from behind. So, Lordship, this is a basic ground,
Where is that?
Lordship. Lordship, may I provide a copy of this special extract?
That's a kind of page 8 of my.
The ground of objection taken, is taken is that the motorcycle in question was hit by an unknown vehicle, and in that regard, due evidence was adduced. However, the learned tribunal, while deciding on the question on the issue number 1, have failed to take into consideration the evidence on record in the proper perspective. Full stop. That is the only ground. Yeah. Taking into account the said ground of objection, the instant appeal is admitted, call for the record steps to be taken by the appeal. And the other one is a stay, the issue notice stay, complete stay, till the next date. Notice issued, returnable, maiding in returnable on 21st of July.
25.
Same lawsuit issue, the person was hit by an unknown vehicle lawsuit in a main national highway, and police has given final report against the FIR. In FIR also it was mentioned that some unknown truck hit this person, and GD also said lawsuit the truck would not be traced out, and accordingly final report was submitted. Despite the final report lawsuit that has been exhibited by the DW as the insurance company has it, adduced the evidence as DW, Lani trial court did not consider the respect loss.
Final report, what did it say?
The offending vehicle would not be traced out loss. It is mentioned in the final report.
Then
So lawsuit, there is no case against this.
insurance company.
Lawsuit, I have annexed the GD.
Then why did the trial court
Time of filing their claim petition, they have annexed a Form 50 report from the same police station lawsuit, and they have given a track number. Wherein lawsuit, in the final report also police has stated that although the claimant tried to implicate the driver of the said truck, that truck, yes, lawsuit.
Yes.
Yes, lawsuit will find page 67, the transmitted copy of the page 67.
He's written such a long judgment.
No, lawsuit page 67 only the type copy of the search sheet.
Huh?
Final report was.
How much it has been given? 11 lakhs.
Yes, yes.
The ground of objection taken is that the evidence on record suggested, so placed, indicated that the vehicle in question, that the accident took place on account of an unknown vehicle, but merely, and which is also reflected in the FIR.
Yes, final report.
FIR,
FIR is also unknown. It is mentioned as unknown.
FIR, comma, as well as the final report. However, merely on Form 54, the learned trial court tribunal had come to a finding that the accident took place. The accident happened on account of the offending vehicle insured by the appellant insurance company. Taking into account the said ground of objection, the instant appeal is admitted, call for issue notice, economic notice করে দিব। Civil application and the file issue notice করে, taking into account the ground of objection, notice making it returnable on 23rd of July 2025. Returnable for stay till the next date.
Deeply obliged.
26 for hearing under Order 41 Rule 11 CPC.
Yes, any urgency? Motions will take it later on. Ah.
Operating as.
Okay. Oh, that one, that section 5, see
Yes,
8, item number 40, na?
Lordship.
Oh, you can bonal niki order kita. Ikon যোৱাকালি দিছিলো। Appearing one and
Yes,
two,
M. Sharma.
who is appearing for respondent number one and two?
M. Sharma, his name is shown in the cause list, Your Lordship.
Service is complete.
Yes, service is complete, my lord.
You are appearing. Mr. Sharma, you are appearing in item number 40. Okay, we fix it for next week for admission. We finish it off. On the, this is on the question of section 8, that without there being a,
First statement.
huh?
Over the dispute over the first statement, because we have filed in written statement and.
Yes.
This is the.
And so, Mr. M. Sharma appears on behalf of the respondent number one and two to stop accordingly list the matter. And accordingly, as the service is complete, list the matter for admission on 23rd of June,
No,
two
sure,
thousand.
after 20th, before 20, before
Are you
19.
senior counsel? Senior counsel doesn't mean since this type of things. We'll engage somebody else. It is the conveniences of the court
Yes,
or the
yes.
advocate on record, not about the senior counsel. On 23rd of June, 2025. Interim order passed earlier shall continue till.
It's in the IA, Your Lordship.
Huh?
It's in the IA. Right.
Interim order passed earlier. Anybody?
Item 48,
Ah.
password for the timing, very simple matter, man.
Which one?
48 supplemental.
Motion? We'll take it up at 4:45. Don't worry. We'll take it up. Not now.
Item number 32 and.
26 after 2 weeks. I will leave, come up after vacation. Can be, 2 weeks is coming. Okay, after 2 weeks. This is after 2 weeks.
Item number 29, there's a stay, 29.
You filed the affidavit of
Yes,
service
I filed the affidavit.
of notice by trustees,
It has
not
been
yet
served, ma'am.
received.
It has been served.
Filed it?
I filed
When?
yesterday, ma'am. I have a copy also.
It has been submitted by Mr.
Yes, sir.
Anybody appearing? Anybody
No.
appearing? No. It has been submitted that the affidavit of service have been filed yesterday. So taking into account the above, list the matter on 18th June 2025 for admission.
May I please, interim, madam?
Interim order passed earlier shall continue till then.
Highly obliged. Item number 32 and 37, Lordship, may I kindly fix on 17th
32 and 37.
37.
There is an interim order.
No, Lordship.
For 32, I am appearing, madam.
What is 32?
32 intested case, Lordship. Our station advocate is there, Lordship, in this case, Lordship.
So this is, you are, anybody is appearing 32?
Yes.
Oh, this matter, the Roman properties.
Yes.
Mr. Srivastava goes with that. Okay. Any date, we fix it for hearing?
Yes, 17, 18, 24th, as per your.
Huh? No, no, not before. This is not before vacation. We'll have
Yeah,
it
after
in the month of August. I think they are taking into account that the service is complete. And LCR has also been received from the appeal, at least the proceedings and the present proceedings for hearing on 12th of August 2025.
August 20. Both the matters, 32 and 37. Both
32
are
and
Roman properties.
37.
37.
37, it's okay. 37, what is that for?
That is jurisdiction of the civil court on company matters. Your Lordship heard.
Oh, that one, no?
They have appeared.
Okay, this matter we take it on that day. Is there a stay?
Possible. No.
Then we have it. As you are appearing, we can finish it off. That day, who was the petitioner in this matter? 37? You.
Both I am the petitioner. In both the matters, I am the petitioner. Appeal and. Revision.
37 is the matter on, you can finish it off on 25th of June 2025. Yeah, for admission.
Deeply. 49. 49.
40?
49, item number 49.
And we don't have, I have only item 40. 49 আছে নেকি?
supplementary list.
আৰু এখন আছে। For what?
The Madam
Aye.
have fixed next week, man.
Huh?
41 hearing. 41 hearing.
49. 49, what is that? Motion,
Under order 41, man.
item number?
49, supplementary list.
Okay. When
Next
do you
week,
want
my
it?
lord.
Oh, that matter?
Yes, yes, man.
Okay, that matter. We framed the question, which the other side?
I'm here for.
Yeah, we framed the question and have it on Wednesday, Friday. It'll likhit you. This is an appeal filed under section 100 of the Code of Civil Procedure 1908, challenging the judgment and decree dated so and so. Pusto. The appeal is admitted on the following substantial question of law. Whether the learned first appellate court was justified in dismissing the appeal on merits when the appellant was not present, when the matter was, had not appeared. So, question mark. List taking into account this and
This is another question, man.
what?
My evidence was expunged by the trial court, and this issue I raised in the
You
appellate
take it
court.
in the first appellate court.
Yes, so we raised this in the first appellate court.
We are in second appeal.
Yes,
You
ma'am.
take that issue in the first appellate court. You have taken that issue in the first appellate court,
yes,
then
yes.
why should I raise this issue here? Because you see, first, if that issue is being decided, I'm going to remand it back.
Yes, yes.
I don't need to go for that because that
Yes,
will require this. Pusto, list this matter, taking into account the sub question of law, substantial question of law. List the matter again on Friday for final disposal at 2 p.
Friday.
Right,
Item
we
number-
finished.
28, Your Lordship.
Ah.
Item number 28.
Order 41.
Yes, what has happened, this, the earlier analogous matter, Your Lordship had already admitted. This is with regard to the counterclaim, the title suit. Your
When do you
Lordship,
want it?
So can be, means that on the same substantial question of law, Your Lordship may.
No, 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 no. This, the counterclaim has to be dismissed on that ground. Other ground. We'll have it on, when?
Friday, Your Lordship.
Oh, Friday, on 25 June.
Obliged.
Okay, okay, no more. Yes. Motion.
Item number 39.
Motion, interim order is what the extend. Now take out the motions. First motion to.
Item 2.
Yes, you are challenging the order of 16-5.
My lord.
You are challenging the order of 16-5.
No, my lord. My lord, this is the, my lord, the second appeal on, my lord, dismissal of the second appeal. Then again, my lord, the execution case that was started in the first dismissal of the title suit after 11 years. Without, my lord, correcting the judgment debtor's name, because during the pendency of the second appeal, judgment debtor was dead, my lord. In case of that other substituted defendant has come, my lord. So that was not rectified. Without rectifying that, my lord, the judgment debtor's name and substituting the other person, he proceeded on the old dead person. my lord.
So did you file an application stating who are the,
47
who are the judgment debtors now?
47 was filed, that was rejected. Now, 10
Huh?
pound was taken, my lord, there.
You have filed a 47.
Yes, my lord. And also we filed a SLP also preferred, my lord. It has been filed also Supreme Court. So my prayer is, my lord, that at least without rectifying the name of the judgment debtor, how that can be possible? Amended as he expired in 2015.
Who are the legal representatives?
My lord, this present one petitioner, my lord, the Podum Das, my lord.
Why have you not mentioned it? Who are the legal representatives? In before the trial court, why have you not mentioned that?
No, my lord, this has already been substituted, my lord, this in during the second appeal.
Understood. The decree cannot be executed very well. Why are you not filing it?
That is the duty of the, my lord, the plaintiff, my lord, they have to correct this thing as per the.
You
second
give
appeal.
the names.
My lord, I am already names are there, my lord, in second appeal.
You give the names. Go and give the names. They will do it.
It is no problem, my lord. Thing is about it, before that they have to rectify all the things, my lord.
There's nothing else. They will only have to substitute. That's all.
Moreover, my lord, this decree also not executable because my lord, they have paid for the 2 lakhs, 2 katha, 12 lessa. But the decree was given in 2 katha 16 lessa. That is also my lord defective decree. In original
That the
case-
executing court will do, is it?
That is also raised, my lord. That is not.
That the executing, where is it?
Yes, my petition, my lord, this is annex two of my petition.
Huh?
Annex two of my petition, my lord.
That the same was
I
for
raised the all the
recovering
things,
the
madam.
land measuring 2 katha 12 lechas, that is 1/3 of the mark. Measuring.
Decree was given 16 lesson.
You create a decree of union using mark over R, I think you get the permission over share of the amount amounting to 2 katha. No, they may have a claim of 2 katha 12 lecha. Court may wrongly or rightly give 2 katha 16 lechas.
They are going for it to 16 lesson.
So very well they can. That is a wrong thing in the judgment.
It is true, my lord. That is
But
the
there
thing.
is the land of 1 bigha 2 katha 16 lechas.
This is, my lord, my humble submission, my lord, already the judgment letter, the original, my lord, defendant, he one expired.
Go and give the names.
I have already.
I'll pass the direction. Don't worry. I'll pass the direction.
But the field land, my lord, that will be state, my lord,
Huh?
because we have.
No. You go and give the names. When is the next date fixed? When?
SLP is preferred, my lord.
When is the next date? Huh?
SLP is preferred, my lord.
Let it be preferred. SLP, I have nothing to do.
No,
When is the next date fixed before the trial court?
it is. But structural matter is not given to exact date, my lord. Probably with this one, another date is given.
Find out the date. We'll take it up to a day after. List the matter day after. Because there is a judgment of the Supreme Court, 1998 3 SCC 380.
Yes.
You can very well. This is V. Uthirappa or something versus Arsaf Ali. And there in paragraph number 22 or 15, they categorically mention how it is to be done. You will give it. The proceedings does not abate. Proceedings will remain. The court will give him a chance. And the court, they will amend and bring it on record. Matter over. It's a simple thing.
That to be done as per the section 15, my lord.
Of?
50 of CPC. That is to be followed.
Section?
50, my lord.
Why?
Because this is procedure is given how this execution will be conducted after the date of the one judgment letter, my
No,
lord.
that they will do it, but the Supreme Court has laid
But-
down the law
But
for
this is-
that.
But law is very clear. Responsibility is only my lord. Judgment decree.
You give the names.
My lord.
Very
Already
well.
subsequent, they are already been recorded.
Don't worry. The discourse is not going to stop
But this
this
is
thing.
rectified by themselves, my lord. This is not my responsibility, my lord.
Now, then go to Supreme. One SLP is already there, the second SLP will be there. File together.
No, already that will be decided because we
No,
are.
let that SLP go there and another
My
SLP.
last favor, my that is reversed, my lord. This is my
So
my
that is-
humble expectation, my lord.
Monday, Friday. Next.
Injunction order was vacated on the ground because the petitioner reassured that he is the owner of the land. Land is mutated in his name, he is paying revenue. And 22-23, my lord, the land was given to the opposite party for cultivation. Considering that, my lord, the restraint order was there by the court below, the appellate court had vacated the order on the ground that they were admittedly in possession of the suit land. Because the cultivators to whom the owner has given the land for cultivation, they are admittedly in possession of the suit land. And they are just custodian, my lord. They cannot be the, your lordship knows, my lord, position on the basis of the, my lord, when the owner has given them for cultivation from in the year 22-23. Then after 24, he says, my lord, you please vacate the land. He did not vacate the land. So therefore, we filed a suit restraining him to enter and continue in position.
But they are in possession.
They are in position, but they are custodian, my lord. They are my lord, custodial position only. They are not. in
They are
possession.
permissive possession.
Permissive, not, yeah, permissive,
Permissive possessions.
permissive position, but they are not.
But can you stop by way of an injunction?
Yes, my lord, your lordship knows that I don't want to say paragraph 97 only, no?
Of
Yes.
Maria?
Maria, yes.
Maria 97, but this is a case of a suit.
Suit, yes.
So this is a case of a suit, but we are concerned with an injunction. The question is as to whether he is in permissive possession or not. These are questions of facts which are to be decided in the suit.
Yes. But at the same time, when 20.
So the only thing, Mr. Das, I can do today is I'll issue a notice, let the other side appear, then we'll consider if there is any order is required to be passed.
In the meantime, my lord, should be, they are in position, they are continuing forcefully, my lord, in the land.
They have been all along from 2012, so then
Yes, your lordship will decide. Let's
issue
notice.
notice. How many defendants are there? One,
One.
two. One,
One different.
you can serve it before vacation.
You can say. Firstly, if your lordship
Issue
provides-
notice making it returnable on 26th of June 2025. Steps be taken upon the respondent, sole respondent by way of registered as well as usual by tomorrow. Full stop. In addition to that, the petitioner is also given the liberty to take steps upon the respondent by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. Full stop. The petitioner have assailed the order dated 34/2025 passed in Miss Appeal number case number 18/2024 by the Court of the Learned Additional District Judge at Jorhat. Primarily on the ground, the Learned First Appellate Court erred in exercising its jurisdiction over the order of injunction passed by the Learned Court of the first instance. He therefore submitted that that the scope of the appellate jurisdiction being very limited, the Learned Senior Counsel submitted that as the scope of the appellate jurisdiction is very limited, the Learned First Appellate Court ought not to have, in the present facts, interfered with the order passed by the Learned Court of the first instance, taking into, be that as it may, it is seen that that the impugned order was passed on 34/2025, and the matter having been taken up today in the month of June, it would not be proper on the part of this court to pass an ad interim order, ex parte order. Accordingly, this court shall pass appropriate orders upon the appearance of the respondents on the next date, upon service upon the respondents on the next date.
So let's stay vacant. Stay petition.
Huh?
Next date, stay petition your
If
lordship.
it comes before me, I finish it on next date.
48.
Mr. Mahmood, tell me, you got 3 minutes.
Very simple, my lord.
Huh?
Actually, I have filed a title suit
Uh.
for right title in interest that is pending. My evidence was closed. On my prayer of my learned counsel, he verbally made a prayer that our evidence is closed, but we want to give some official witness as the witness because the attesting witnesses have already died. So that was rejected, only for that purpose. We have not killed any time. On the next day we filed and the learned court said it is delaying tactics.
What is the next date?
Next date is today. Today is the next, so I have been asked that you bring the order to, that is why I was in urgency.
There is no urgency, because you have not moved, were not present when the matter was there. Okay,
Hello?
will you have it on Friday? Is the matter on Friday?
Friday.
Anybody appearing on the other side? No.
No, there is no caveat.
Get the date. Today you get the date.
My lord, if your lordship may kindly dispose of also the matter.
I can't without other side. Without the other side, it would be difficult. Otherwise, I would have, and if I can dispose it of on Wednesday. On Friday. I'm having it.